Urgency.
My lord, that is single judge order with regarding to the land acquisition, my lord. And the land acquisition is going on.
No. So we'll hear on Monday, Tuesday.
Published.
Good.
My
Tuesday.
lordship, for lunch motion press matter, my lordship, with regards to the medical admission. I was already admitted in the college and I was attending the college, my lordship, and now we all of a sudden fixed the cancel.
All right.
Your Lordship, there was direction in the writ appeal to permit the students to appear for the examinations, Your Lordship. But the university is not allowing the students,
Now,
not allowing the students to enter the classrooms. So, the classes,
file a contempt, right?
14th admission, it's 14th.
Contempt you have filed.
We'll file, we'll file. We'll file.
You have filed.
We'll file.
Why didn't you file it?
Okay.
File a contempt. What can be done? There is already an order. We cannot pass any other order, right? Yes.
Subject Lordship, kind Commissioner.
Yes.
We got item numbers 110, 111, and 112.
Huh?
Item 110, 111, and 112, my lord.
110.
Yes, my lord.
And?
Here, 111, 112. These three matters, my lord, writ appellant advocate who is suffering with vertigo problem is not doing well, my lord.
Oh, we will see when it is called. We will see. Don't worry.
May I make a mention, Lordship?
One minute, madam. Yes.
Obliged.
Item 64 to 81. Item 64 to 81.
No adjournment. Sorry, 10:30. No adjournment. It will be called. Yes. Yes, madam.
Lordship, I have filed contempt case CC 1250 of 23, Lordship. The matter was adjourned to 17th August. And then I made a mention and given letter to registrar. Till today.
Why do you want for admission? You want listing on for admission?
No, Lordship, there is a direction, Lordship. The learned single judge has passed order with regard to stipends of Ayush.
Why do you want it to be listed?
Because, Lordship, there is a direction to be ordered to be complied within
Final
3 months.
hearing or what?
You want final hearing?
Yes, Lordship, final hearing.
File an application for expedite hearing.
We will consider.
Obliged.
We'll consider.
Obliged, Lordship.
What is today's date? 10th. 9th. Nice.
Item number 60, Lords.
Don't you want to withdraw? No. Wait. For the aforementioned reasons, order dated 29/3/2023 passed by the commercial court is set aside. However, respondents 1 to 6 shall keep the accounts with regard to printing, marketing, publishing and distributing or reprinting, etc. of the You give it in the morning itself, like in there, so that we initials can be done, right? So,
Hello, requesting account for petitioner method. This is a content matter cover for the first time method. Notice is also received.
so you issue notice, madam. Notices have to be issued, you issue notice.
You have to argue on admission, madam. It's not simple.
At least say, I mean, that coming up first, every coming up first time, all cases notice should be issued, right? Then why everybody of you is sitting here? Go away. We will issue notice in every case. Why have you come to the court? Just to tell that notice has to be issued. Then
Okay.
this petition has been filed.
Right.
Hmm.
And this appeal filed against the orders passed in writ petition number
Hmm.
193/94 of 2021. The brief facts of the case is, Your Lordship. The appellant before Your Lordship is none other than the brother of the respondent, number 1. Your Lordship, the father's property was, Your Lordship, misrepresenting the fact, Your Lordship, he got it transferred on the name of the respondent number 1. That was challenged by the petitioner.
So the court only says, I mean, the sum and substance is that you should take recourse to the remedy available to you under the Act.
Your Lordship, yes, Your Lordship.
Para 12.
Yes, Your Lordship, I have seen that. Your Lordship, that section.
So what is your contention that it's not
Yes,
maintainable?
for which my submission, Your Lordship. The section 40 proceedings will be issued by the, competent authority under Tenancy Act. That is exclusively applicable for the tenants' lands. That was also observed by the, the authority issued the succession. Kindly look into Your Lordship. The authority issued the proceedings, page number 51. 51 is starting, 52 is Your Lordship in the result. The petition filed by the appellant, namely Adaya reference second set above, allowed for grant of succession to the protected tenancy of the Booreddipalli Nagadu for the land bearing number 52, 53, 54, 55, but not 81/2. So this was misused by the respondent number 1 and got transferred the entire property of father on his name. That is Patta land, but not the PT lands. So the application of this, Your Lordship, the petitioner, the appellant challenged before the appellate authority. The RDO rightly held, because under ROR Act, there is no other remedy except filing of an appeal under section 55 of the ROR.
Why the finding we want to understand? Why the finding recorded by learned single judge that the order is without restriction is incorrect?
Yes, madam. Learned judge under impression that, Your Lordship, I have challenged the succession proceedings under section 40 issued by the competent authority. I have not, but I have challenged the proceedings where the father's property was transferred on the name of the own brother. So that was challenged, Milad. Kindly look at Your Lordship, appellate RTO.
No, this the order which was challenged in an appeal is, this is page 51.
Yes, Your Lordship. That is, Your Lordship, I have not challenged this one. I have not challenged. This was utilized by the respondent number 1 for transferring of the Patta land on his name, entire land. So kindly look into Your Lordship, page number 45. Page number 45. This is the order passed by them.
1 minute. You mean to say that appeal under section 90 lies?
No, does not lie, my lord.
Then,
My lord, your lordship, section 55 is the,
does not lie.
Yes.
So you mean to say that appeal under 55
Five-
of ROR Act?
yes,
lies?
madam. I have filed that also.
Which is that order against which you had filed an appeal?
My lord, page number 45, my lord. Page number 45, my lord.
Ah,
This is an appeal filed under section 5 of TS Price and Land and Patedar Passbooks Act, aggrieved by the, because this gentleman as a respondent number utilized the succession proceedings for transferring of the patta.
no, so this,
The relief sought, my
on
lord,
appeal,
my lord.
the order which was challenged in appeal,
Miller.
it was passed by which authority?
My lord, that revisional authority, section 9 of the ROR Act,
Not getting right.
that is
This
35.
order,
Yes,
This is
48. No, this is 55. Which order was challenged in an appeal under 55? See, he has said in para 12. The Revenue Divisional Officer entertained the appeal against order of succession dated 4/8/2014. No, Tehsildar's order.
That is MRO section.
4/8/2014. So this is an order passed under section 40. Appeal lies under section 90. That's what single judge has held. But we don't know what is here. 4/8/2014. Where is the order? 4/8.
4/8/2014 order, which page?
pardon me.
4/8/2014.
2014 order, my lord, page number 51. my lord. Five one. And 52, my lord, will actually be finally allowed that taxation proceedings were when observed, my lord, I am permitted to read, my lord. In the result, the petition filed by the appellant, namely V. Yadaya, reference
So what
second.
is the, madam, section 40 of the act? What is? Not a tenancy act, tenancy. 40. And what is ROR Act 55?
Sir, your lordship.
Section 40 of Tenancy Act first.
My lord, this is the subject.
No. Please verify. The protected tenant. For grant of succession. So it's an order passed under section 40, right? Yes. So why do you say that this is not an order under section 40 of the act?
Yes, your lordship.
Why?
My lord, your lordship. Page number 52, my lord, your lordship. May I kindly look into the proceedings issued by the Thai succession proceedings, my lord.
Yes.
There, my lord, in the result, the petition filed by the appellant so and so is allowed for grant of succession to the protected tenancy of the lands for the land bearing number 52, 53, 54, 55 situated in Gonda village, Mahbubnagar under section 40 of APTA Tenancy and Agricultural Lands Act in the above said persons in the legal areas of the protected tenancy, namely so and so, my lord. So now the land in survey number 81/2 exclusively a patta land. So these proceedings cannot be applied. That is the reason, my lord, your lordship, appellate authority RDO has passed the order, my lord. Kindly look into the RDO's order, my lord.
No, but is it not an order granted?
RDO's order, my lord, page number 40.
The petitioner is a protected tenant.
The other lands, my lord, but not the patta land.
Why did you state that's not there?
My lord,
See, the succession certificate is.
All the grounds can be raised, mister. It's not that you are rendered remedialist.
my lord,
Instead of contesting the writ appeal, you have to file an appeal under section 90
90.
against this order.
90, my lord, your lordship, I am not disputing with regard the issuing of section 40 proceedings. I am contesting, my lord, your lordship, the patta land exclusively, I mean by way of succession, but not under the 40, my lord. That is my submission. My lord,
Then this is an order in their favor, right? On an proceeding initiated by them. If you want some other land or patta land, whatever land, you initiate a proceeding in accordance with.
yes, sir, that,
How are you agreed? You are challenging this order dated
No,
4/8/1994,
my lord,
2014, according to us.
Well, your lordship.
Please assist us.
Well, your
This
lordship.
order, according to learned single judge, can be challenged only in appeal under section 90. All grounds you can raise, not patta land, whatever
my
land,
lord,
whatever.
section 40
There's
speaks.
nothing right.
My lord, what's up? My lord, your lordship, section 40 speaks about the, my lord, succession of the tenants, but not the patta holders. Then, my lord, your lordship, the question that, my lord, the patta.
This ground you can raise in an
No, I
appeal
can't
under
raise-
section 90.
I can't read, that is the reason why section 55 Harbor Act, my lord, your lordship, kindly look it, I may permit.
No. Every order and appeal lies
Right, section 55 appeal, that
section 90.
90 is not applicable for this, my lord. This is a patta land. So, my lord, your lordship, the tenancy proceedings cannot apply to the patta lands.
Arey, Mister, even if a wrong order is passed, that's why a remedy of appeal is provided. You cannot say that this act does not apply. Who will determine that applies or not?
That is the reason.
That you raise all grounds that this act does not apply. This ground also can be raised in an appeal under section 90.
My lord, one sir.
We can say that if you file an appeal, it will be dealt with on merits.
My lord, kindly bear with me. The ROR Act, my lord, your lordship, section 55, kindly look into that, my lord. Section 5 deals with, my lord, your lordship, amendment and updating of the record of rights.
Or-
On receipt of the intimation of the fact accusation of any right referred to section 4, the Mandal Revenue Officer shall determine as to whether and if so in what manner the record of rights may be amended in consequences therefore the small carry out the amendment in the record of rights in accordance with such determination. So, my lord,
Does 5 provide for an appeal?
section, my lord, 55 my lord, before the appellate authority RPO, my lord.
No, where is, we are not getting anything.
Section 55 is there, section
5 is registration and effecting change.
ROR Act, my lord, ROR Act 1971, not new act, my lord.
What is our Telangana rights?
Right, in land and patta or passbook settlement.
To
So that is
2020.
not 2020, it was amended. Earlier, my lord, your lordship, there was. Sir, kindly look
Hey,
into this.
Madam, what is? You don't even give the correct. Take it from him. She doesn't know. At least these two acts, madam, you keep right. Arey, mister, you note down this thing, these acts and keep the copies available. It's your duty also. She doesn't know. What like? In the court of Chief Justice, we don't have the acts in which we are dealing with. That gives wrong acts, doesn't understand what can be done. Recording. Yes. Yes. 5.
Yes, madam. So that is the reason petitioner chosen the remedy available under law, ROR Act, my lord. 45 order passed by the appellate authority, my lord. And the relief sought under section 55, my lord, page number 46, my lord, it was mentioned that also, my lord. It is therefore requested to allow the appeal by setting aside the order so and so of the Tahsildar Mahbubnagar Mandal. Consequently, direct the Tahsildar to record the name of the appellant to the extent of 36 guntas for his share.
He's coming. You see to it, fix it. Yes.
Lord your lordship, the relief sought, my lord your lordship, to the extent of is the land must be protected to the extent of that he preferred an appeal under section 55. My lord, that was allowed.
recording authority, who is the recording authority? This is an order passed by the. This is not an order under 5.1. Amendment and updating the record. It is not the expectation. This is section 40 land revenue. Correct. Yes.
Milord, section 55, Milord, your lordship, we preferred. In that also, Milord, your lordship,
Supposing if somebody has purchased the land by way of sale deed, that provides section 5.1 for record of this thing, recording that right. Yeah. And if in case person is aggrieved, he can file an appeal under 5.5.
Yes.
This is a case of devolution of interest by inheritance, which is recognized under section 40 of the Tenancy Act. So, prima facie, in our opinion, subject to what you argue, the learned single judge is correct in saying that an appeal under section 90 lies.
Milord, basically nature of the land must be whether
No, but what is like, I mean, what's your problem? It's not that you are rendered remediless.
Milord,
All you have to do is to file an appeal under section 90.
Milord, your lordship, my submission,
I
Milord,
mean, I really,
the tenants,
supposing if by learned single judge would have rendered you remediless, then we would have understood that you have no remedy for redressal of your grievance in law.
Milord,
He has simply said that, and prima facie correct, that this act, this 5.5 appeal does not lie in respect of an order passed under section 40 of the Revenue Act.
Milord, my submission,
Subject to what you argue. You please
Milord.
tell us why an appeal,
Milord,
how it is not an order under section 40 and why appeal under section 90 does not lie.
Milord, my submission, Milord, the nature of the land, if it is in a protected lands, Milord, then the PT Act will
So who
be.
will decide? Mr. High Court will decide under Article 226. It is a this thing, protected land and everything, 226, and quash everything, declare your title here.
Milord,
This is what like.
one submission. The recording authority will know that it is PT lands or Inam lands or private quota land.
No, this does not lie. Section, there has to be an answer to para 12. Yes.
Milord, the nature of
Does not depend, right of appeal does not depend on nature of land. An authority under the act can pass a wrong order, right order. For that only appeal is provided. He can raise all these contentions that this land, that land. We can't decide under Article 226.
Milord,
Yes.
one submission I will submit, Milord, your lordship. The nature of the land will.
Perhaps we must tell you that we are not inclined to examine and record a finding that this is the nature of the land under Article 226.
Yes, sir.
This is completely beyond the scope, according to us.
Milord, your lordship.
The scope is confined to examining the validity of the order which was challenged in a writ petition. The learned single judge, again we are telling you, you know it, that has come to the conclusion that appeal under section 5.5 of the act does not lie. You should have taken recourse to the remedy under section 90.
Milord, one submission. I will submit, Milord, your lordship. Only the thing is that, Milord, the nature of the land will be recorded in the revenue records. That, Milord, whether the lands, private quota lands, Inam lands or government lands or the nature of.
No, your contention that what we are trying to tell you, Mr. Counsel, contention that the act does not apply because it is an Inam land or Y land or red land,
Milord,
that can also be raised in an appeal.
Milord, I will submit one thing, Milord, I will leave it to your lordship. Only the thing is this, Milord. The observation of the court below is if it is,
Not court below.
Milord, I am sorry.
Learned single.
The single jet, Milord, if it is
When you appear for respondent, then you argue that the.
Yes,
No. When you appear for respondent in an appeal, then you tell us the scope of intra-court appeal and say that this court only corrects its error made in exercise of jurisdiction and is not an appellate court. When you are appearing for the appellant, you immediately go to addressing learned single judge as court.
I am withdrawing that. I am sorry. Milord, learned single jet is under impression that nature of land is PT. It is not
Whatever PT or whatever, we don't know.
Milord, one submission, I will prefer the appeal as per the orders of learned single jet. Now, Milord, you will have to protect the interest of the party, Milord, not to take any further recourse. Now they want to dispose the property, Milord.
Let them
So tomorrow there will be an out of, this thing will after.
file a suit seeking the relief of injunction restraining them from alienating the
Checking.
property.
Milord, your lordship, here the thing is that, Milord, your lordship.
Not like
Nature of land itself, Milord. The RTO himself has stated that it is a PT land, not PT land. The order kindly look into, Milord, the appellate authority order. Appellate authority order kindly look into, Milord, your lordship. I may permitted to read this, Milord. Page number 49, Milord. But 49, as per the one admission of the respondent himself, late Pureti Narsai has got the two sons of appellant and respondent. So both the parties, appellants and respondents, have got equal shares out of their father's share, 81/2 to an extent of so on. So each party entitled so on to. As per the register stated, alone sold to the extent of so on so. But the Tahsildar Mahbub have wrongly made entry to the remaining land in 1 acre 21 gunta in the name of the respondent without considering the appellate share. So out of remaining land 1 acre 21 gunta, survey number so and so, have got the 36 guntas, and whereas the respondent got 21, only as he alone sold an extent of 15 guntas to the said so and so can be included in the share of the so and so. In view of the above, facts and appeal is allowed with any direction to the Tahsildar Mahbubnar so and so.
So what are your submissions? Number one, it is not what RT land. What
It
land?
is not PT land.
Huh?
It is not PT land.
PT means
Protected tenancy land.
not a protected
Tenancy land.
land. Therefore, provisions of Tenancy Act do not
Not
apply.
applicable. And survey number 81/2 is exclusively private patta land.
Survey number
81/2 subject land, it is a patta land. And the appellant is entitled by way of succession his share of the property from in the land of the father. So the respond number alone cannot get transferred the entire land on his name. Third one, he misrepresented the succession certificate obtained for the PT lands and got transferred the patta land on his name.
there is no an appeal is provided. I don't know what. Here it is wanted to be non-limiting with justification. Yes.
The respondent misused the succession proceedings issued under section 40 of PT Act and Protect Tenancy Act and got transferred the patta land on his name alone, which is not permissible under law. That is my submission, Your Lordship.
That's it. Yes. This intra-court Yes.
Appeal is preferred there against the orders of the learned skill effective 2022.
Yes.
Learned Judge Millard. Here, in view of the memo which has been issued, Millard, by the
What
government,
happened to this order in WP 328?
I was not a party to the writ, Millard, in the writ petition. In view of the orders, Millard, passed by the government on
What
23rd,
happened to the WP?
orders have been passed, Millard, regarding the registration of the documents. There was a direction, Millard, to consider the petitioner's claim for registration of the documents, Millard, in the writ petition. In the writ petition, I am not a party, Millard.
Has been disposed of on the ground that in common order. I am asking.
I'm
what
appearing for
happened
the
to-
response.
She is not understanding what happened to the order dated 18, whatever 18/2/2022 passed in WP 328. Has it been challenged further? What happened or still stands?
328.
Huh?
Went in SLP, Millard,
Yes, SLP is pending, my lord, with regards to the
SLP.
memo.
before the court.
With regard to the memo, my lord, issued by the government, not to alienate certain type of lands, my lord, not to register certain type of lands.
Huh.
That they were set aside by the division bench of this court, my lord, against.
Which order?
My lord, they have
You-
been
Mr. You also.
subject
don't-
matter of SLP, my
No,
lord.
no, no. Order dated 22/2/2022 on which reliance has been placed, has been set aside.
No, my lord. They have been disposed of, my lord, directing the registration subject to the.
Array, Mr. You don't. First, therefore, listen to the query.
Yes,
What is the case? We have to tell you the case also, right?
I apologize.
Ah, really testing our patience all the time, Mr.
I apologize.
This is, I mean, as if it is our case, we have to, all right, we have taken oath, we understand, but, and we are doing it but we have to tell what is the facts of the case.
I apologize. but
What
there's
has learned single judge done
to follow the orders passed in WP 328, my lord.
and has disposed of?
Yes,
The obvious question is whether the order on which reliance has been placed has been challenged in an appeal.
No.
No,
No.
it has attained finality.
yes,
You have accepted it.
yes, my lord.
You are a party to this IA, this thing, WP 328.
Yes,
Yes, madam. Now, what is your challenge?
So, I am challenging the orders.
You said that SLP is pending.
SLP is pending, Millard, before the court, Supreme Court. I filed.
No, where is the question, madam? This WP.
I filed the extract, Millard, and.
No, Mr. WP is, where is this order dated 22nd February? Still not clear, Mr.
not in fighting.
Is 2022. No, 22, this modified. Where is this order? It is passed by division bench or single bench?
The division bench order was only to the extent, Millard, regarding.
No. We are asking, madam, this order referred to in paragraph 3 of the impugned order. There is an order, right?
Yes, Millard.
What is that order dated 18/2/2022?
Yes, Millard.
So the query is whether it is passed by a division bench or single bench?
Single bench,
Single bench.
single.
He says it is not challenged by anybody. What happened to this order?
The division bench order has been challenged, Millard. Considering the division bench order, Millard, the single judge has passed this order. And that division bench order, Millard, has been challenged and it is in the Supreme Court, Millard, at
You
page
need it,
206 I have filed, Millard. That is the 94, the writ number is 94, Millard. It has been referred in the,
See, madam, paragraph 2 of the order impugned. It's a consent order. If you are aggrieved, then file a review. Right? Read para 2 of the impugned order.
so para 2 has been modified, Millard, later.
No. Para 2 of the impugned order.
Yes,
It is submitted by learned counsel on either side. That subject matter is covered by common order. Having considered before the learned single judge it is covered, you file an appeal and you are saying that I am not a party and all that. Go file a review. Review before the remedy is to file a review. It's a consent order. Understood?
this, your lordship may kindly see, Millard, this order single judge has passed this order, my lord, batch of matters.
Read para 2.
My lord, it is submitted the learned counsel for the either side subject. The writ petition is squarely covered under the common order passed in 320.
You have conceded, madam. If you have wrongly conceded, then the remedy is to file review.
I am not a party in the writ, my lord. I am not a party in the writ.
Madam,
My
the question is, this order was passed on the consent of both the parties. Please read para 2 onwards.
yes, my lord, 328 and the
Consent
batch.
of either side.
No, what she
Modified the
says
order.
is I am not a party.
What
So you are,
read that at the early instance.
My grievance is, my lord, my land has been, respond number 5, misleading the court, my lord, has obtained this order and he has,
what has happened? That the document has been registered now.
yes, my lord, it has been registered.
Then what, beating around the bush now, what can be done? The order has been implemented.
I will file a suit, my lord, for cancellation of the
fine.
sale deeds.
Fine.
That's correct, my lord. It is
That's the
understood.
correct remedy. Yes. See, you also know what is the
Yes, my
remedy.
lord. But whereas this order is standing on my head, my lord, that there is a direction by the court
No,
for
no,
registration
nothing.
of the documents, my lord,
No.
to consider.
We will clarify that, madam. We will clarify that it will not, observations contained in the order shall not prejudice your rights in prosecuting the remedy.
Your
We will
Lordship,
clarify.
can you take up the learned judge's order, my lord, where it has been modified in the 8th February?
The order has been
That,
given
that
effect.
order, my lord, modified order also, your lordship may kindly take up, my lord, page 90,
It's only provisional registration.
page
Only
90,
provisional
199, my lord.
I clarify. Every registration will have an endorsement at the back. It is subject to SLP. So all the parties' interests are protected.
Tell her what to do.
Madam, in this order, if you carefully see this, all the registrations.
Yes.
At the back of the registration document, there will be an endorsement subject to the outcome of the SLP so and so, which means that the interest of both the parties are protected. It's only a provisional registration.
But in view of the registration, my lord, that they went forward and now the suit
Cannot
has
be
been
the-
filed and not to interfere
Madam, once the
because
matter-
my sale deeds.
Please, once the matter is sub judice regarding all, it appears that one survey number is being
It's
questioned.
related to a memo, my lord. It's related to a memo.
So when it is sub judice,
view
you
of the-
cannot take a different view.
In view of the memo, my lord, the division bench also has passed an order and that basing on the division bench order, my lord, the single
Where
judge
is
has
the
passed the
division
order.
bench order? We are asking you repeatedly, what is the number of the WA?
WP is 94, 1 minute, I just refer. 9248 of 2021, my lord. Your lordship may kindly take up the material papers, my lord, 188. The learned judge has also referred. Despite the learned division bench passing an order dated 23rd August 2021 in WP 9248 of 2021, which operates REM, several documents presently before the concerned sub-registrar offices are not being entertained by the grounds of the aforesaid memo dated 26/8/2020.
To find a suit, we can't do that. Yes.
So in view of the orders, my lord, division bench orders, the learned judge has passed the orders, my lord, and based on that, the learned single judge. And I am nowhere concerned, my lord, with the respondent number 5 misleading the court, my lord, has obtained that order. And that order has to be suspended, my lord. Again, is only my specific prayer is this order, my lord, in the writ petition which has been passed against me has to be suspended. I am not questioning the order in large, my lord, because the Supreme Court, the matter is pending before that. And when I go to the lower court, my lord, the lower court, instead of setting aside the sale deeds, they would ask, my lord, as there is an order of the learned single judge of the High Court, my lord, they will not entertain my suit, my lord, for cancellation of the sale deeds. So once my sale deeds.
See, registering officer cannot decide the question of title, madam. You are disputing his title.
Yes.
You are claiming the title, but a mere registration of a document, it does not, is not a proof of title.
Because
We are saying that we will protect your interest provided you file a suit. What can be done? This order has been given effect to. Sale deed has been executed when, Mr. Sale deed, provisional sale deed, when it has been executed.
22, my lord.
20, for 8.
Second May 2022, my lord.
So then what can be done? In this writ appeal, he cannot set aside the sale deed, right? And this is the prayer which you are seeking.
My sale deeds are in the year 2016.
Whatever, but please understand, Two constitution benches of Supreme Court have said that the High Court under Article 226 cannot adjudicate the question of title. And we are aware of it. We have followed those constitution bench decision. We are not going to hold in this writ petition that your sale deed is a prior in point of time. Therefore, you are the owner. He is not the owner, and grant you a declaration of title. That we will not do.
In view of the directions of this honorable court only, this sale deeds have.
No, if your understanding is like that, that if the court gives a direction for registration of a sale deed, that it amounts to declaration of title, we cannot help it, right? We can't. What can
That
we do?
is, they have entertained this sale deeds. Now that my sale deeds in respect of the same property are executed in the year 2016, and subsequently he comes and says that the partition has been not affected and this property comes to me, and he obtained this order behind me, Milan, not making a party in the writ petition, and now these sale deeds are standing, and after the sale deeds have been executed, they file a suit for injunction not to interfere with the property. So unless and until Milan, the order of the learned single judge is suspended, I can't, because the suit also will not be maintainable, Milan, with regard to the cancellation of the sale deeds also. That's what my.
So, learned single judge is also held that if a sale deed is executed, it cannot be challenged in any court of law, right? That
No,
is also.
that is not.
How you are saying matter? What can be done? Go ahead. Anything else?
My liberty, Milord, in the low court, your lordship may make it clear, Milord, this order, the order of the learned judge will not come in the way for the cancellation of the sale deeds, Milord. Then my interest will be protected.
We told you that in the beginning itself, madam. We told you.
Obliged.
Heard on. You call, it's a serious matter. Call
Yes.
Advocate General.
I beg to represent Mr. Harsham. There is a delay of 143 days in representing the appeal. But the validity of the memorandum issued by the third respondent was under challenge. But you ask me kindly see the writ prayer. Writ petition at page 31. Page 38 would love to find the writ prayer.
Yes.
But now, when the memorandum issued by the third respondent was under challenge, that the first respondent issued notification that appointing third respondent as the appropriate authority. Notification is at page number 92 minute.
But learned single judge has said something in para 10, page 14. In the absence of challenge to GOOM dated 24/4/17, no relief.
That's the reason I read the prayer. That's the reason why I read the prayer. So in fact, there was a challenge to the memorandum and legally, according to us, it is not valid. That's what we
It
said.
has been challenged.
It was challenged.
Page.
Not, writ petition starts at page 31. Para prayer at page 38.
38.
May I read, madam?
Oh. Yes. This intra-court appeal has been
I request a date, madam.
issue notice. We don't know when they will be served.
Because
Personal notice, proof of service, whatever.
I'll take it out 2 weeks time.
List after 2 weeks.
I'm applying.
Mr. Advocate General, see, this is a silence zone and repeatedly we are, this thing we have, you have to use your good officers to ensure this. I mean, our prima facie impression is that the noise pollution rules do not apply here. I mean, people are at least under this impression as a leader of the bar and as a state, as this Advocate General representing the state, it is your duty to ensure that this is all this thing. We had to tell Mr. Srikanth.
Yes.
He is engaged with the ROR Act, not concerned with noise pollution. This is you have to see to it. You talk to the administration, and this must stop. This is a silent zone. If it is not, then please issue this thing. Whatever it takes, we will have to take. Otherwise, suo motu action. We don't want to. Before we thought that we will initiate. we thought that we should speak to you. This is like if it is happening in the like vicinity where we are working, what would be like this thing in the city? Please. Yes.
Apply.
Item 6. Issue notice list along with WA 1051/20. List along with WA 1047/2020.
There is a stay petition in this matter.
We have in another connected petition, we have issued notice.
In this matter, my lord, a direction is given to the bank to return the title deeds in 6 weeks, my lord, 6 weeks time.
Don't read, this is sub judice, right? What will happen? Your application is pending, right? IA issued notice on IA 1 of 23 also.
Lord, may put a stay, my lord, it will not do any. The direction is to direct.
There is another writ appeal in which we have
In that I have not filed a stay petition, only I filed a stay petition in this matter only.
Why?
That is the only request is only to put a stay.
What will happen? If don't return the document, what will happen? They will initiate contempt. So when this thing, it will come up, we are issuing notice, right? There is no threat of contempt as of now. Or has it expired?
It is actually 6 weeks is coming, my lord, ending. That's why your lordship put some limited stay also, no.
All right, then argue. Yes. Item 6. Yes. Yes. What is the appeal about?
This is an appeal, my lord, filed by the bank against the order of the learned single judge, directing the bank, my lord, to accept the money deposited by the borrower. OTS. And my lord,
So there is a judgment of the Supreme Court which you did not tell us, right, on the last date of hearing, unreported judgment.
Yes,
Learned counsel for the appellant. This intra-court appeal emanates from an order.
Please, Your Lordship. So writ petition is filed questioning the action of the respondent number 1, my lord, in issuing a temporary revocation of closure.
To execute the application, my lord, we are going to place the same year before the task force. Task force committee has to be reviewed, my lord, their application.
Mike. Yes.
On 30th August 2023, my lord, they given a complaint. Application, my lord, they request is to dispose of the application, my lord.
Dispose of the application? What application?
The complaint given, my lord, the revocation order is given to the fifth respondent. But
when they have given a complaint?
On 30th August.
All right.
Will dispose of.
They will take an action on your complaint.
Yes.
Correct.
Some specific time may be given, my lord.
Yes, of course, 3 weeks after hearing you and this. In this
Apply to them.
Subject to your lordship pleasure, my lords. Item number 7 was not called. My lord. There was confusion.
There is an order, it is to be listed along with another writ appeal.
Yes, yes, my lord. That's 1047.
Yes.
May I please your lordships?
So have you challenged the order of allotment? Just
This case is placed before your lordships for the orders of this court while issuing the number under PL category, my lords. This petition is filed for the protection of government land itself. Registry is not issued
what is
directly.
the prayer? See, government is unable to protect the land. You are coming forward.
My lord, I filed a
What?
representation because
Prayer,
competent
prayer.
authorities.
No, nothing, no representation. This is what is your locus and what is the prayer. This all.
My lord, page 8 and para 3.
No, what is the prayer? How can we this? We are not a revenue authority, right? We cannot delete anybody's name in the revenue record, and we don't
my
maintain.
prayer is to
No, 1 minute. Do we maintain the record pertaining to rights of people in the land in state of Telangana? High Court maintains the record.
My lord, yes, obviously, my lord.
Yes.
Yes. This, my lord, this case is
Where it is maintained, we don't know which wing of the High Court maintains the records of people holding rights in the lands in state of Telangana.
my lord,
What does the
that's not,
Tahsildar do and the authorities, revenue
that
authorities?
is not my case, my lord.
This is Mr.
My lord,
We don't want to say anything.
negligence
further.
act of the official respondents only while protecting the public property. I filed this writ.
No, nothing. No need to protect public. This is what is this committee? Right to Information Protection Committee. What is this? A statutory status?
No, you're right.
A constituted under law. Who are you?
Just I'm a social worker, my lord. Right
all like
information committee. I'm a
making
social
demands. You must have visited respond number 5. He said, all right, I will not
I
entertain you.
for respond
You
number
must have
district
told
collector.
that, no, I will see you. Then how will you not make payment?
No,
Right. This all, Mr. This is an admitted fact. Process of public interest litigation. To what an extent it has been abused. What? Yes. No. What is the prayer? Prayer in the petition. Please read. First of all, who are you? What is the status of this committee? What is?
My lord, I am a social activist, my lord, in the name of committee. I collect
We are
information.
not the committee. You are not this thing. This
Help
is
the public to
what is-
reach the government officials.
what is the status of this committee? Is it a society registered under societies? What is it?
It's an NGO,
What?
my lord. NGO, registered under NGO.
Where?
Registered. Registration number is there in my applications also, my lord. In page 25, my lord. My representation before the collector, along with the registration number.
You are an RTI activist. How are you concerned with this thing? If it an issue pertaining to right to information, we can understand.
My lord, I received informations from the concerned departments. Later,
So now you are got into the business of vacating the government properties, right?
I approached the competent authority, my lord.
Filing
Myself
petitions.
not involved. I approached the district collector to
This all-
resume the public property, which was transferred
This was the
illegally.
allotment of land in favor of respond number 5 has not been challenged. Therefore, we cannot grant any order directing in a public interest litigation, directing deletion of somebody else's name and this thing.
After inquiry,
This
sir,
is-
let them
no,
inquire
no.
into the matter. If it is legal or illegal transfer in the name of fifth respondent.
That's all. Anything else
But
you want
technical
to say?
welfare
We have
board is-
told you that the order of allotment has not been challenged. We asked you to
But-
read
but
the
there is no-
that you have not done.
There is no order, my lord. There is no order. As for the Tahsildar clarified that.
File a
there was
civil
no
suit.
file. How he was.
No,
admitted
you have the remedy of filing a civil suit.
But I'm
file a
not
civil
interested
suit.
party. I'm not an interested party. It's only a public.
No, you seek a declaration that this is
Well, I'm
government
not
land.
interested party. Only for the.
No, on behalf.
Well, there is
Whatever.
no valid allotment. As your lordship stated me that for the challenging the allotment, there is no allotment, my lord. As for the declaration given by the Tahsildar, there is no allotment, my lord. There is no record for the allotment. And also, Sainik Welfare Board certified that there was no recommendations from the Sainik Welfare Board also to assign the
At
land.
least spare the ex-service person who have served the country. Spare them. Spare them. Don't, he has served the country,
if it is
being in
valid-
army and has got some land, you are after him, right? So if he spends his time after serving the country, he will think that if this was what went to be, that I have to remain, I have to spend my rest of the time in the courts, then what's the purpose of serving the country?
But there is no
It's all
valid.
frivolous, Mr.
There is no valid
No,
assertion.
there is nothing, no antecedents disclosed, nothing. We will dismiss it. Give that PIL order, that locus. We have passed an order despite that you people are filing such. Leave at least Mr. Ex-serviceman. Have respect for them. He has served the country, right? He must have been allotted some land. You want to challenge it and you want to see that he spends rest of this thing in the courts. It's all misconceived.
Permit me to withdraw.
Best thing. After arguing the matter to some extent. Yes.
Alright, in this matter, for second respondent, we are filing a counter, Wakalat, my lord, for filing compliance report, your lordship may have it after 3 weeks. It's a contempt matter.
Compliance report. Learn it. So this is on an early hearing application.
Yes. I was informed.
All right. So we'll consider it sometime in third week of December. Let Mr. So and so learned counsel for respondent praise for his.
Public.
Next. Heard on the question of admission, appeal is admitted for hearing. Yes.
But item 13,
We have admitted. Total 6 for admission. We have admitted.
16 also go along with that, Malad.
Huh?
Item 16 also.
16.
Yes, Malad. Go along with that, Malad. I need to file an application to bring the liquidator on record. Malad, subsequent to filing of the appeal.
The 15 also same, right?
No, 15 is different.
Different. All right. 15. Call 15. Yes, 15. This is what? No, this what order? Huh? No, what has which order under 34? Yes.
Bit to appear for the appellant's minutes.
Huh?
Bit to appear for the appellant's minutes.
This is an order passed on section 9.
Yes, minutes.
So what has happened? Arbitrator has been appointed? No.
In this matter, we have engaged senior counsel.
No, not senior counsel. We are asking you whether arbitrator has been appointed.
In fact,
this is Mulad. May I, Mulad, I beg to represent the counsel on record, Mr. Ramarao. He is not well. This is Mulad post-award, purportedly a post-award section 9 application. Mulad, seeking Mulad certain directions not to recover. On the ground that Mulad, we are seeking to recover.
No, but post-award, you must have instituted post-award, no? So
Yes.
So then award has been challenged in the proceeding under 34.
Award, Mulad, is challenged, Mulad, and the CM, and it's pending before the commercial court.
Commercial court. So then why section 9 then?
Mulad, the contention of the applicant, that's the respondent before the commercial court was that, Mulad, appellant before your lordships is seeking to recover certain amounts which were claimed by way of counter-claim before the arbitration.
All right, in any case, he wants an adjournment, right?
in fact, senior counsel is representing senior counsel is representing me, Melody.
I am representing the senior counsel.
Oh, acha. He was seeking time. Yes. We are not ready. 23 appeal we will not hear.
Lordship, in this only a small matter is involved.
File an application for early hearing if so advised. Right? Admitted for hearing.
December minutes.
Please file an application for early hearing. We will hear it. Admitted for hearing. Next. No, nothing. file an application for early hearing, we will fix a date, Mr. What is? We are
Bless you, Lord.
Yes.
We'll do that.
Yes. 16. Yes. Yes, what? You are praying for time.
Yes, ma'am.
Learned senior counsel for the appellant. Yes. What? Anything survives? Nothing.
Let's, I have filed.
Restored?
It's restored.
Then
Of the order, for which I have no objection.
what modification?
That, if 6 weeks order was there, how the OP has been restored, he has made his submissions. My submissions are also very fast.
Yes.
Continue on 13th of October. Please, that let the order be modified, subject to the result of the main OP itself. That's what he's saying. So that I have no objection from that modification because with the change circumstance. As to the OP having been restored.
There is an interim order, my lord, of stay in the commercial OP in 35 and
No, so
30
you want the order dated 22/9/23 to be modified.
to be modified.
That deposit made under the order, the interim order shall be subject to outcome of the OP, right? That's it.
That's it.
All right. Yes.
My lord's a fixed time, my lord, for completion. Once
He said no.
No, but not complete. No, what I'm saying, my lord. Yes.
So what? 2 months.
In the petition. No, my lord, I'm saying, I'm requesting.
4 weeks.
4 weeks.
4 weeks. That fine. Fine.
That's
Yes.
all.
Oblige.
Wait, please, Your Lordship. My lord, I request 3 weeks time to file some additional citations, my lord, in support of my case. This is a case where I seek to resolve the, my lord, issue with regard to the reference court, my lord. Though, my lord, under section 30 of the Land Acquisition Act, the officer is entitled to refer the matter to the court. Which court, my lord, is the question of law? Whether it will be the court as defined under, my lord, section 3 of the Land Acquisition Act.
Last time also you.
Yes, my lord, Your Lordship wanted me to file some more citations. I got the citations, my lord, I'll file it, my lord. Your Lordship may.
No, we do not want. It's for you to support your case.
Yes, to support my case, my lord.
You have see. You have sought for adjournment.
Yes, but the issue that falls for consideration is.
No, that's correct. We know the issue.
Yes.
We know the order. That dispute with regard to entitlement of compensation arises in respect of a property owned by the Waqf. Therefore, it has to be referred to Waqf tribunal.
Because under section 83 and section 7.
So, thereafter, something else. How he prays for adjournment to substantiate the aforesaid submission.
Yes, I have got the judgments, my lord.
Therefore, we did not want.
I understand, my lord. For my convenience, 3 weeks time may be granted, but I have got hold of some judgments, but I will rely upon it. But the issue that is to be resolved is which court.
It's coming up after, Mr. It's coming up after 1 month. You still want 3 weeks time. What can be done?
I have got it, my lord, but I was unaware of that. It will come suddenly, my lord. So, just 3 weeks time.
Please argue.
I will certainly, I am ready, my lord. I am ready.
Ready?
Almost. I am almost all ready, my lord. Just
you are ready and still seeking adjournment. What is this? Something.
Just for the sake of citations, my lord. Nothing else. Otherwise, I am ready with the facts and everything. I am all ready.
No, we are also ready. So go ahead.
My lord, just.
Now go ahead.
Just
You are
citations.
ready. Just now you will get an order.
Just citations, your honor. One opportunity, my lord. I will certainly convince your lordship that I am.
Say so, Mister. What is this? I am ready and this thing, as if I am giving an impression that the court wants to adjourn. We are ready.
I apologize, sir. It's not.
Then you will say that last date of hearing your lordship had sought an adjournment.
No, I apologize, my lord.
Anything like, don't, Mister. We don't like this. And the order sheet says you have prayed for adjournment. We never wanted. Why will we want you to cite? Don't cite.
I understand, my lord. I apologize.
Don't cite. Your appeal will be dismissed if you don't support your case. Don't say that court wants and they say, why will we want? We are not work board. We don't own the property. Nothing. And we don't want compensation. So why will we want you to this thing?
Apologize. I stand corrected, my
Don't.
lord.
This is, and always remember that you are, when you appear before this court, you are under an obligation to maintain. All the time we do it because this thing is waft, right? We maintain the decorum. That doesn't give you a license. We thought initially that when the live streaming of the proceeding begins, the performance of lawyer would be better, but we are disappointed. We only wish that if you go to any other expert, he doesn't behave like the way you are doing in this case, right? If you go to a doctor for an operation, he doesn't perform the surgery the way you are dealing with the case. That he gives you a date for surgery, then says, come after 3 weeks.
I apologize, my lord. I stand corrected.
And no further adjournment. If you are unable to handle, engage somebody else.
No, I am ready.
We will not adjourn.
I will do it.
Ready? So then argue. Who is preventing you? Ready means, again you have said ready, then argue. There is no question of adjournment. Go ahead.
Ready in the sense, my lord, I am ready to handle the case, my lord. But lordship may kindly accommodate me for 3 weeks. I will certainly come up with some citation and support my case.
No, it was listed 4 weeks ago.
Yes.
And after 4 weeks it is coming up. What is if 4 weeks you cannot get the case law, that means we will lay down the law. Yes. This Telangana High Court will be the first court if according to you there is no decision. We will do it. Go ahead. You are ready, no? Please, you have told us twice that I am ready. Go ahead.
Accommodation.
Yes. No, nothing. No accommodation. You said that I am ready. There is a limit to things, mister. Simple thing is you are wasting the time of the court for nothing. Wasting the time. This we could have taken up other case.
I apologize.
Despite our head and
I
we will,
undertake to argue.
nothing.
I undertake to argue by next week.
You have to.
Yes.
And there's nothing great about it. Yes.
Like, apologize.
So now you don't come. We will decide it. Now we don't need your assistance, right?
I will pay.
Yes.
Sending petitioner counsel, my lord. But
Huh?
I can be accommodated by 1 day, my lord, because senior counsel is engaged in this matter. He has been arguing this case, ma'am.
Huh?
It will be taken up
Now, what is under challenge?
My lord, the order of the trial court, my lord.
Huh?
Order of the trial court in surface.
Trial court?
But surface act.
Huh?
But I don't have the bundle right
You know what?
May I assist the honorable?
We know it. Notices issued by Advocate Commissioner. 2 notices issued by Advocate Commissioner is being challenged. He says trial court. That shows
My lord, I don't have the
I
bundle
will
with
see,
me right
Mr.
now, my lord.
The burden is entirely on us. That we appreciate. Entirely on us to decide the case. And he has the right to file SLP. That's all. He need not know what is the case about. Doesn't know.
My lord, I was just asked to take till tomorrow, my lord. Just tomorrow.
They just asked to. We are not granting time. End of the matter. Who grants? Who decides that
Your
adjournment should be granted or not?
Your lordship.
So you have been asked. We have been asked not to grant adjournment.
Not only
Why?
one day I
So who will prevail?
Your lordship.
No, you have been asked to seek adjournment. We have been asked not to grant adjournment by Supreme Court. What has Honorable Chief Justice of India said in last 3 days? Did you come across that instead of focusing on seeking adjournment, the lawyer should argue because more than 50% matters are an adjournment is sought. And this is, you don't realize, Mr. This is an effort. It requires an effort. This is wastage of machinery. Somebody has worked on it, has prepared the list. How many man hours? Just stand up tomorrow, day after, 3 weeks. Why you come to the court? Just to this thing, behaving like a postman. Why do you come? You are this thing.
I'm the counsel.
You are dealing with this thing, art of adjournments, how to seek adjournment. Supposing if we ask you, why should we adjourn it to tomorrow? What is the answer?
But senior counsel is representing in this matter, my lord. It's not available. Yesterday night only after lockdown, this matter came up.
Where is your file?
My lord,
Appearing empty-handed.
No, man. File. This particular file is not with me right now, my lord.
Then why are you appearing? It is this thing, the case is listed before us. We will deal with it. You don't have the file. You are not in a position to assist.
Tomorrow will be. The file is with the.
No, Mr. We don't. I mean, we don't appreciate this practice.
I'm just asking for accommodation for 1 day, man.
Hey, what 1 day? Why 1 day? We have gone through it. We are telling you what is the order. You don't even know. You are saying order of trial court. Should we record this and send copy to your client that this is what is the preparedness of your counsel representing you in the court? Like no impact on you, Mr. This your performance is being washed. Don't feel ashamed of yourself that you don't know what is the case about and just standing up.
Sorry.
Don't come to this. We feel sorry that despite spending 3.5 months in Telangana, we are unable to give you a message that this court doesn't believe in granting adjournment. And still you have the guts to seek an adjournment. And you know what order will be passed.
Finally, I'm sorry.
There is no question of being sorry. The problem is you can't ever realize There's no big deal in adjourning because we have already read it. We can pass an order tomorrow. The problem is, if we grant an adjournment, we don't have any other. So many people are waiting to seek adjournment. Everybody, nobody wants to argue. So we have to grant adjournment in every case because there is no justification. What is the ground like of seeking an adjournment? At least tell us.
But we have engaged a senior counsel, my lord.
Yeah, the senior counsel has to be there, Mr. It cannot be, it can never be a ground that when the case is listed on that day you engage a senior counsel. And it is against the this thing conduct for senior advocates to get engaged when the court is before, when the case is before them. Nobody, I was a senior counsel, I never accepted a brief when the matter was before the court. I always told that you get an adjournment and then brief me. What is this? Like, I mean, you are making it a ground that senior counsel will appeal?
The file was
filed an application for early hearing also.
Yes, filed. He has filed because seeing the trend that we don't entertain, so he suddenly remembered, oh,
No, my lord, unconditional stay was granted. I filed my counter within 28 days.
No,
Along with the stay vacate.
lighter when we are saying something, not like. Don't come, Mr. This is the last case and last this thing. Don't, we will really, don't appear before this court to seek adjournment. We don't like it. And especially young counsel.
Yes.
But like, think about your future. Otherwise, do something else. If you're not interested in prosecuting your career as an advocate, do something else better. You will not get anywhere by seeking adjournment. You have to argue. If you have to succeed like your senior, you will have to begin arguing. There's nothing in this case. Nothing means, I mean, nothing which requires your senior to argue. These are the notices issued by Advocate Commissioner which you have challenged. This fact you can, but you are saying trial court, I have challenged the order. Unfortunate. Praise for adjournment. Come now. Yes. Don't come tomorrow. No, don't come. We don't want you to come to seek an. Now, in any case, the order will take effect. Stay will stand vacated tomorrow. So there's nothing you can do. Don't come to seek adjournment. This is not, Mr. It's not good for your career as a young person.
Appear for the petitioner, my lord. My lord, seek your lordship's indulgence. In this matter, we had filed a reply on 30th. It appears the office has returned it. We searched, but the returned file is not available. Your lordship's permit, I'll pass on my reply and proceed with the matter. Otherwise, your lordship may have it after a few days. We'll search for the file and resubmit it.
You file first. You are appealing.
We filed it on 30th.
You are saying that it has been
USR
returned.
number 106270, that was returned. But the return file is, it appears.
So return means you have to file it again or you are not to file?
The return file is not found, my lord. So we could not resubmit it. If your lordship's permit, I have the extra copies.
No, return means how it is returned?
Some objection would have been raised.
Given back. So then he has to easily come and file it again. So he is saying I am not required to file it.
No, I am saying that.
No, the copy is with him.
Yes.
Returned. So then you have to refile it, right?
When we went to get the return, take the file return, that could not be traced. So we are just searching where that. It seems to have been misplaced.
He will direct you to this thing office to return.
Yes.
Now, are you serious about it? It's not
Yes,
being,
my lord.
because it
My
will
lord, I have-
entail some action on somebody, right?
No, my lord, what has happened
By
is that
misplacing the record, like it's a
No, my lord,
serious thing.
we filed it on 30th, it was returned. My colleague went to check the return file and resubmitted. The return file could not be found. Maybe it's just misplaced or they're searching for it. So we are on the job, my lord. But however, if your lordships permit me, I have
No, no,
extra
this,
copy.
you filed it, mister. It's not on record, right?
It is, yes, my lord. I need to resubmit it. I have already served it on my friend on 30th.
Let him file it. We will take it up next week.
One submission is correct. Here in the matter, my lord, under the DRT Act, where recovery officer passed an order without filing appeal under 30, is before this honorable court assailing the orders of the recovery officer.
We will hear him, next week we will hear him.
I will.
You want to file a counter? What, you are petitioner?
I have filed my reply, my lord. That is what I want.
Means rejoinder. Reply to counter.
Only the legal counsel on what is the.
So what, Mr. Yes?
My lord, I'm ready to proceed. I only request your lordship.
No, what is proceed? The answer is, just now, he is.
Yes, my lord. My lord, my
appeal does not lie.
my lord, my objections is on 3.
No. Appeal does not lie.
My lord, appeal lies, but
Lies.
I'll submit to your lordship that the proceedings are without jurisdiction and I'll on 3 grounds, my lord, and I'll convince your lordship. I am ready to argue.
All right. Next week. Learned counsel for petition. Yes. Infructuous.
It becomes infructuous.
Learned counsel for the petitioner submit.
With the lordship's permission, my lords.
Huh?
My lords, my consequential prayer to direct them to allow me now under the amendment rules, if your lordship so pleases, my lord. My consequential prayer is to direct them to provide requisite information under
So now the rules have been amended, you apply. There is no reason to believe at this point of time that you will not be supplied information.
highly obey. I'm grateful to you, lord. Apply.
My lord, in this petition in 23-24 connected in 24, I have filed the IA for 6 date.
We'll consider it in the month of January.
Oblige my lord.
Right.
Highly oblige my lord.
Let IA 1 of 20, because we want to finish some old matter. There will be some holidays, no? First week, yes. Yes.
My lord, sir, I heard this matter yesterday. That's one. Passing on a synopsis, my lord.
$25, madam, which case? 23, 25. Yes.
Yes, my lord.
Anything else?
My lords, two more submissions,
Rules,
my lords.
Madam
Two
Cooperative Society.
additional submissions, my lords, we made in this matter, my lords. My lords, the government had issued the memo pursuant to the RBI directions, my lords. The power that the government gets is under Section 131 of the Cooperative Societies Act, my lords. Section 131 has not been gone into yesterday, my lords. Section 131, my lords, of the Cooperative Societies Act.
Yesterday you had given me a file, right? So there are some notes. Yes.
My lords, I need permit to read the section, my lords. Power of government to give directions. The government may generally or in any particular matter under this Act issue such orders and directions which are in accordance with the provisions of this Act and in the interest of cooperative movement in the state as they may consider necessary to the registrar, and thereupon he shall give effect to such orders or directions and shall report to the government in due course the result thereof. Subsection 2. In any case in which a direction has been given under subsection 1, the government may call for and examine the record of the proceedings of the registrar and pass such orders in the case as they may think fit. Provided that before passing any order under this subsection, the person likely to be affected by such order shall be given an opportunity of making his representation. My lords, the impugned memo in the writ appeal, my lords, has been passed by the government under section 131, my lords. Nonetheless, it has been passed upon direction from the Reserve Bank of India, my lords. However, parties who were affected included the appellants as well, my lords, because they had agreed to get the mortgage property as a security for their loan under the assumption and belief that the same would be sufficient enough to secure their liability, my lords, in the event of default on their part. However, only an amount of 23 crores and odd sum, my lords, was secured by the bank, thereafter almost leaving the appellants in the same place as they were before, my lords. My lords, one last submission, my lords, in this regard would be that even if we say that it is left to the discretion of the bank to decide on how or in which account the amount recovered should be adjusted, the same discretion cannot mean that it would be violative of Article 14 and it would result in discrimination of the towards the appellants, my lords. These are the two submissions, my lords. And my lords, the memo itself places.
This is an extraordinary discretionary remedy under Article 226. Your conduct in not making payment and being a defaulter and usurping the public money disentitles you to any discretionary relief. Right? You cannot talk about Article 14. First, look into your conduct. What have you done? You are banking upon somebody else. What have you done? Show by your conduct that how much amount did you pay to the bank. Taking a loan from the bank and thereafter filing a petition. This conduct, madam, this entitles study. We will advise you to study about extraordinary discretionary remedy. Despite everything in your favor, we will not invoke it in your favor because your conduct disentitles. You are a defaulter.
My lords, my ground would be that the other defaulters who were along with me, against their loan accounts, it has been adjusted, my lords.
Yeah.
The inequality, the unequal distribution, adjustment, when another defaulter is being treated in a favorable manner, then a defaulter such as me, then the problem would be.
Defaulter means
Yes.
Article 14, right?
Yes, my lords.
Yes. All right. Anything else?
One last submission, my lords. I'll take my lords to the impugned memo, my lords, on page number 73. My lords, when there is reference to the public auctions being conducted earlier, but somehow the government has not mentioned how the respondent number 5 has suddenly appeared and offered the amount, my lords, for the sale of the proceeds. There is no proceeding to show, there is no communication that is mentioned.
There is absolute non-transparency in this manner, my lords. Once the public auctions were conducted, suddenly resorting to a non-transparent manner makes the entire process a little. I rest my.
That's it. Anything else? Please feel free to argue. We will
No,
hear
madam.
you. We are only trying to. Your senior has entrusted you a difficult case. Yes. Anything else?
No, my lords.
That's all.
Yes, yes.
Feel free to argue. We are not preventing you from arguing anything. That's all.
Yes.
Yes. Mark the presence. Yes, madam. Right.
Malad, I appear for respondents 12 to 14.
Yesterday you argued why
Yes,
it doesn't mean that this is a rejoinder. Yesterday you have concluded.
Yes, I concluded. I concluded. I was not audible.
No. Supposing if the other goes against you, we will hear you again.
No problem.
No problem. Oh, good. Thank you. Yeah. Oh. This intra-court appeal emanates. Please sit down, madam. This intra-court appeal emanates from an order dated 8th of October 2010 passed by learned reading after something strikes to you. This is what your senior has argued before learned single judge, you are bound. And always remember, though you argued well, but always remember that you have to, in an intra-court appeal, you have to point out what has been held against you and you have to demonstrate how it is wrong. Like it's not a fresh proceeding. It's not you are arguing as if it's a writ petition. Not it's an intra-court appeal. There is an order against you. You have not made any attempt to demonstrate how that order is wrong. Just arguing arbitrary, no opportunity of hearing all this. New contentions which were not raised cannot be raised in this intra-court appeal. Right? On the other hand, You have argued well, but next time, madam, what you should do, like find out why your petition has been dismissed. Tell the court that on these grounds my petition, and that's how.
Much obliged.
Yes. Oh. Yes. 26 to 26. Oh, yes. What is it? Huh? Yeah. I'm passing the order. Yes.
We request some time, my lords, because.
No, nothing. 2006 matter. No time.
Yes.
Yes, Mr. Chaudhary. Yes.
My lord, this matter is come on remand from the Supreme Court. Two matters which have to be heard together. That was the direction of the Supreme Court. That matter is listed at 8252. My lord, because it came last night, we couldn't find the whole bunch of papers. Frankly, I tell your lordships, I couldn't get the whole bunch of papers. But because I have appeared in the Supreme Court also, I am aware, from my memory, my lord, that other matter which is challenging the removal of difficulties order. That is writ petition, I think, 82.
Whatever the bunch is, these petitions of the year 2006 after remand, so
it went from the.
we will agree that it needs to be heard.
No, but just 2006 was where division bench quashed the demands. It was for cross-subsidy such as demands, quashed the demands relying on removal of difficulties order. On that basis, the division bench quashed the demands, and that was then it was carried to Supreme Court. In the Supreme Court, a representation was made that we have.
No, that's all right. So, but when will you argue? You are obviously seeking an adjournment today. We are only concerned 2006 writ petition. 14 and 3, how many? 17 years.
82, there is some issue there, my lord. That they have to start.
So let them start.
That has to be done first. But in that, we have filed complete petitions. That needs to be all. 8252.
Right, you will be heard.
So I can't tell you, but there are complete petitions pending in 8252.
No, let it, you will be heard. There is no this thing problem.
Because we have to file a counter also there after completion.
No, not what counter.
And
See, somebody had filed a petition in 2009 for early hearing. 2009 a writ petition was filed for the application was filed for early hearing. Fixed in early hearing.
I don't
2009. We are telling you item 47. Please see. 2009 application pending for early hearing. We want to hear. Yes.
In that, my complete petitions are pending. There are batch of complete petitions.
No. So you will be heard, right? And the pending means like what? You will be heard. The object is to be heard, right? We are telling you, we will hear you.
The central government has to file a counter. We have to be implemented, and then we have.
Nobody is appearing for central government to even pray for counter. We cannot send an invitation to them.
My lord,
They appreciate.
The council's name is not printed as old something. They must have missed it, man. Somebody would have been there. It's challenging the removal of difficulties order issued under the.
Whatever, we'll deal with it, right? Whosoever is challenged, we will see. I mean, what can we do? I mean, we cannot invite central government, come here and file, please file. What if they don't, nobody appears, you see. They are not bothered. They have removed the difficulties by issuing order. You are facing difficulties. So now it's for you to argue whatever whosoever has said. They are like that only. What to, Mr. Please? That's the only difficulty, Mr. Chaudhary, is no problem. 2006 matters. And only because of these matters, our pendency showing that since 2005 and 6. Yesterday also, one council like you sought an adjournment. Huh?
The rare thing that I ever asked for.
So now you please tell us earliest.
Find the papers.
No, but whatever.
Came back to bundles.
Hey, whatever, we will adjourn, but you next date, please, you tell us when, what will, earliest possible date next week. We will have Thursday.
28th or 29th.
No, 29th is too far. Like next week.
Next week I am not here.
And
Next week I
20th,
have personal.
20th December, 20th November. Yes.
20.
20. Please.
20th.
2020.
I am committed to Andhra, my lord.
No, you should be committed to Telangana also, right? All the time Andhra. And this is like what we feel bad. No, Mr. Chaudhary, one minute. One minute, Mr. Chaudhary. We are told here, this is ground for adjournment that I am busy in Andhra. We said this can't be a ground. This is also a court. And not in any manner inferior to Andhra. Right? Then, what is this?
28th, your lordship.
No, 22nd. We will not. Mr. It's a question of we are struggling every day, Mr. Chaudhary, to tell you to finish the pendency of cases. Please cooperate. We are granting adjournment. Much to our disliking, we are accommodating you. But you should also cooperate.
I have it 23rd.
No, 23rd. 23rd.
Marriage in the family, my lord, 3 days, 22nd, 23rd. The lordship have 28th.
The next year, why? There is no hurry, right? Let it be.
Good out of station, 28th.
You give an agreed date, Mr. We don't know. We don't want to. Please do not ask. Apart from deciding the cases, also decide the date also. Don't ask. This is most unfair.
28th.
At least agree for a date.
28th is fine.
No, you after 4 years also it will be fine with you, Mr. Chaudhary. Why 28? I won't be here after 4 years, so this is fine.
Your lordships are saying this. I don't ask for time normally.
Yes, agreed date, Mr.
28th or 29th.
Learn it, counsel for the parties. Learn it.
Certainly not disorder. Lord God,
Lighter when we said, Mr. Chaudhary. The problem is that the laws are so much. This thing they forget to smile also.
Problem is right.
Because
lot of this kind of orders are 137 are being filed.
No, what has happened is one case 2005 we said no adjournment, then council said I filed an IA yesterday, it goes to the root of the matter. The other council said that I have a right to respond, so we have to adjourn. That's why we have grown wise and we are saying like this that no IA shall be entertained.
In the main matters, in the main repetition.
No, whatever, 28th November.
Just once. The main repetitions, the pleadings are complete because the matters have gone up to Supreme Court and are unremarked. So there is no further thing to be filed in that. In the 8252, which is challenging the virus of that removal of.
You are not the petitioner, right? 8252.
No, but I am an implead respondent who is impleaded.
The petitioner is not bothered about the case. What can be done? What you implead petitioner, you file a separate. No. You if you implead petition means in case you are challenging the order by way of intervention, file separate petition. Why intervene in anybody else's affair?
I'm defending it. Their petition affects me.
So
I am asking.
Our predicament is case has been called 8252. Nobody appears for petitioner. You expect us to we don't know who is appearing.
Mr. Vinod Reddy appears for the petitioner.
So he is not saying anything. You are more concerned than him about his case.
Files are missing, my lord, will actually take.
No, but whatever missing, whatever no adjournment and no IA to filed with to seek adjournment will be entertained. That is very clear. 28th November.
Lordship said 28 or 28? 28.
28th November.
And within respond number 1 to 3, my lords.
See that this bunch they get adjourned. What?
Within respond number 1 to 3, my lords.
1 to 3. Very good. Yes.
The facts of the case are like this, my lord. May I submit?
So these are this thing right covered. See, you have put them in chain. Shocking.
It's a police station, railway police station. Yeah.
So you are not responsible, right?
Well, the responsible officers were suspended on the same day, my lord. And a department inquiry was conducted and a censor was awarded, my lord. There is the hearing officers. And both of them have retired, my lord. One of the officer has already passed away.
He's trying to be responsible.
So these two officers were suspended.
16/6/2000, next day. Incident was on 15/6/2012.
16/6.
They were suspended, madam. On 1/9/2012, madam, the department inquiry was ordered. Deputy Superintendent of Police was appointed as inquiry officer.
Then what happened?
Madam,
Punishment of censor.
censor. And both of them have retired. Sub Inspector of Police, Mr. Tajuddin, was retired in the year 2015, madam. The Head Constable Mohammed Sada, he retired in the year 2020. And the Head Constable Sada is number. Filed a status report, madam, on 28/6/2022.
28/6.
2022. Pursuant to the directions of.
So vaccine you will take para 9. First right claim is public interest litigation released from the business following which prayer has been made. Then I have funded a counter para 9. It also delinquent persons were suspended. Oh, that they have been suspended from 9 punishment of censor, not have limited office. We hope and trust that super confidential never be risky, repeated in future, and provisions of the criminal justice implemented in the finance. This organization was this which is found based on the police item which was reported in India today taken 18 Yes.
Project kindly it may take about 4 weeks.
Huh?
Kindly it may take about that 4 weeks, Lordship.
Huh?
Senior is out of station.
Fine.
Even the petitioner
Let
is
him
the
be out of
MLA.
station. Madam, this is,
Lordship.
please understand. This is this is public interest litigation. You lose locus after you cannot seek like adversarial litigation. If you want to assist us, otherwise we will decide.
Lordship,
I mean, it will not,
petitioner is the MLA candidate, Lordship.
nothing, whatever. You sit down. Please sit down. If you don't want to argue, please sit down. There's no, this thing, it will not be adjourned.
Lordship, last time.
Nothing.
The third respondent. I feel the third respondent. Allotment made somewhere in the year 1983 has been challenged in the year 2012.
Allotment made in 83.
Yes, 1983. So the unofficial respondents. 4 to 8. Moreover, my lord, the state of Telangana is also not party.
No, whatever it is. Don't, I mean, give grounds for adjournments. Don't.
Yes.
Have you filed a counter? No.
It's municipal. Second respondent, my lord.
Where is that? Material papers.
Counter has not been filed, my lord, since.
Very good.
Counter not filed.
See, Mr. 16/3/2022 order sheet. This public interest litigation of year 2012, unfortunate that such old case also reply has not been filed. Let reply be filed within 6 weeks. Private respondents. Then 19/7/2022, the matter was directed to be listed. Nothing. If you keep on sleeping, I mean, what can be done?
Even the unofficial respondents, my lord, what the beneficiaries have not.
They have been served. Served, madam?
4 to 9.
Give that PIL, delay and latches, Bombay dying judgment. PLL. All. Doctrine of delay and latches applies to 2006 SCC. I think it's volume 4, Bombay dying. You don't have SCC online here. Volume, it may be volume 1 also, I don't remember, but Bombay dying is the judgment. Public, the, yes. Yes, Mr. What is it?
Reply has not been filed, my lord.
22 also, I mean, 13 years, 22 also, 4 months time granted. That what should we infer that you don't want to contest, right? That's the only inference can be drawn. We read the order sheet to you.
Yes.
3 months time was granted in 22. Notice has not been issued. Private. Mark the presence. A division bench of this
May please, Your Honor. Representing counsel for the petitioner, appellant, Your Honor. The counsel is seeking an adjournment, Your Honor.
Now we knew the way you are standing up, that's why we are not seeking any assistance from you. Fine, fine. This is a public interest litigation, Mr. Very new, this thing, good library has been established in the Bar Association, right? Huh? Have you been there? Then make use of today's time to find out what the Supreme Court say in Sheila Barse versus Union of India. 88 decision Supreme Court. This all not protecting the government land. It's all. You don't have your land. You have nothing to do with, like, you are eyeing on government land, right? Let the government be bothered about its land. Why should you bother?
There is a civil suit pending in this matter, my lord. I've got instructions today. There is a civil suit pending in, my lord, this matter. A decree has been obtained against the government. A decree has been obtained against the government, my lord.
Decree has been passed
against the government, which has been challenged before the Supreme Court. And it's only a very recently, my lord, it's only a diary number is even.
No. So, judgment and decree passed by the civil court straightway challenged in Supreme Court.
No, my lord, first of it by the High Court. In the High Court, my lord, initially a civil suit has been filed by against the government, which was dismissed, challenging which an appeal was filed.
Where is that?
Not
give the
what instructions, not
in this public interest litigation, comma the post on so and so.
Nineteen 2012, my lord.
Recalled. This is the recall.
Disposed.
Yes. It can't be like this. On this public interest litigation, the petition. Mr. Rao,
Page number 21, my lord.
21, certified copy today.
My lordship, we have filed this petition with respect to challenging the.
1 minute, item 3 and 4, which pages then? Huh?
Same, my lord, page number 21.
21, 3 and 4,
Page number 20, my lord. Same.
21, certified copy today. Yes, item 2, madam, give.
My lordship, I'm counsel for petitioner, my lordship. Senior counsel Ramakant Reddy is supposed to appear in online, my lordship.
May it please your lordships.
Yes.
Lord, the petitioner before your lordships was admitted into the fifth respondent college, my lord, in the last phase of counseling. My lord, the dispute before your lordships is this. Now, my lord, for a second, your lordship may have a look at para 8 of the affidavit, my lord. Para 8 of the writ affidavit, my lord, it has few dates. Then I'll take your lordships to para 5, my lord, and the impugned order if your lordship permits me, my lord. Para 8, my lord, of the affidavit, I'll read, my lord. It is submitted that the counseling sessions were held by the respondent for admissions in the respondent number 4 on the following dates. First phase of counseling between 26 and 2023.
Para 8?
Yes, my lord, of the writ affidavit.
Page 12, my lord, page 12.
Top
11 and 12 top.
I'm sorry.
First page, yes.
I'm sorry. But it is submitted that the counseling session were held by the respondents for admission in for respondent number 4 on the following dates. Phase 1 is 26 to so and so, my lord, to 28 8 23, then 17 9 to so and so, then mop up round, my lord, so and so, then my lord, stray counseling 27 9 2023. My lord, stray counseling, why it is done is, my lord, your lordship may have.
Even after
what you?
Even after, my lord, stay vacancy, my lord, about 86 seats for 12 vacant.
Your lordship may have a look at.
1 minute.
12 vacant.
No, we will hear you. We will hear you, Mr. Counsel. We just want to understand what is the grievance like.
But after stay vacancy,
what is his grievance? What is his
grievance, my lord?
May I take your lordships to paragraph 5 of the affidavit. I'll just conclude in 3 minutes, my lord.
No, you can take it by 30 minutes also, no problem. We just want to understand what is the case like.
Yes, ma'am.
Instead of dates, what I mean, like first phase of this. What is his
I'm
grievance?
grateful, my lord. I'm grateful. Paragraph 5 for a second.
Lord, after stay,
Paragraph 5, my lord.
Lord, after stay,
There is no provision and it is not lawful to change the admission schedule with it. Now, my lord, after the 20% of the course is completed in anatomy, physiology, and biochemistry, now the respondent says, my lord, that new phase of counseling should be introduced based on the Honorable Supreme Court order. Now I'll take your lordships to 3 orders, my lord, and I'll close my lord. Now your lordship may have a look at page 16 for a second, my lord.
No, what you are being shifted to some other course.
No, my lord. Now they say, my lord, at the my lord, first stage counseling, second stage counseling, then mop up round, then my lord, the
stay round.
Stay, my lord. At that,
No, but you have been admitted to a course.
At that
Have you been, 1 minute.
Yes.
Have you been admitted to an MBBS course?
Yes, my lord.
And
20.
What is, they are not disturbing your admission.
Now they are saying, my lord,
Cancelling.
They want to make again counseling based on a notification circular pertaining to deemed universities, my lord. That based on a circular, they are referring to a Honorable Supreme Court judgment which pertains to deemed universities, and they are applying to a state university, my lord, under which my college is affiliated, my lord. So I'll take your lordships to page 16, 17, 19 only, my lord. That will make page 16 for a second, man.
No, but supposing if a stray round or whatever round is held, how are you affected? Your admission is not being cancelled.
They are not approving my admissions, my lord, based on page 16 letter, my lord, which pertains to deemed universities.
What class?
You may see page 16, my lord, for a second. May I read it, my lord?
Yes.
My lord, it says it is dated 7/11/2023 in accordance to the clarification issued by NMC National Medical Commissioner. The admissions made by the institutions into the vacant seats of MBBS course after the last phase of counseling conducted by the university for the academic year 2023-24 are hereby not approved, and the vacancy shall be filled up in a special vacancy phase of the counseling by the university. This was never notified earlier, my lord. Then I take your lordships to, this is based on the reference cited letters, my lord. What this your lord, based on this letter, my lord, the university issued me that letter. Page number 17 for a second, my lord, I'll read it. Page number 17, my lord, it says, to the university by the National Medical Commission, my lord. With reference to your letter number so and so, I am directed to inform you as under. The National Medical Commission by public notice dated 24/7/2023 requested all state counseling agencies to make arrangement for conducting the counseling in online mode for all rounds, including the stray vacancy round in private medical colleges. The National Medical Commission issued public notice dated 24/7/2023 in the light of Honorable Supreme Court orders, wherein it was held that Medical Counseling Committee, Ministry of So-and-so shall conduct online counseling of stray vacancies round for 100% seats in deemed university in UG and PG courses. I am a state university, my lord. I am in a state university affiliated college.
No, no, your admission has been cancelled.
Yes, my lord. They say I don't ratify because of this. One more document, my lord, for your lordship's kind consideration, my lord. One document, page 19, my lord. Again, your lordship says, my lord, it's in a routine matter. Erroneously, they might have issued this. It is, my lord, dated 24/7/2023. Your lordship will recall, my lord, it is referred in the earlier letter also, 24/7. As per the orders of the Honorable Supreme Court of India in IA number so and so in Medical Counseling Committee so and so of Health and Family Welfare shall conduct online counseling for stray vacancies round of 100% seats in deemed universities in UG and PG. My respectful submission to your lordships is, my lord, I am not deemed university. I am not under a deemed university, my lord. I am not connected to a deemed university. That's my respectful submission. And they cannot say, I will not approve your admission, my lord. And another point, my lord, your lordships are away. Your lordships have been time and again reiterating, my lord. Midterm admissions, your lordships have been deprecating, my lord. Day in and day out, every judgment, Honorable Supreme Court, Honorable High Courts. My lord, it's anatomy, physiology, biochemistry. 20% of the course is over, my lord. I request, my lord, your lordships to consider one fact. My lord, anatomy, my lord, half-baked anatomy, my lord, they can't squeeze the course. They can't compress the course, my lord. That's my respectful submission. Now, even if they want to make admissions at this stage, my lord, it may not be so good at all, my lord. It may result in dangerous consequences, my lord. With half an anatomy knowledge, what will you teach the patient? Treat the patients, my lord. That's my respectful submission. I'm grateful, my lord, for the patient hearing.
May I please, lordships? Where the colleges, my lord, after stray round of counseling, but about 86 seats were fell vacant. The colleges on their own have filled the vacancies, my lord. The Apollo Institute of Medical Sciences have filled, my lord, 12 seats. And they sent, my lord, to the university for approval. That is at page 22. My lord, the university, my lord, refused to approve. Page 22, my lord. My lord, they addressed a letter stating that they have given admission about 7 candidates in their college on their own and requested my lord to approve the my lord, admissions. My lord, the university, my lord, refused to admit the admissions at page 20, my lord. Then the page 20. Because the college has no authority to fill their seats. They have refused to apply. Then, my lord, the university, my lord, addressed a letter.
So on its own, they admitted.
On its own, they admitted.
Without counseling.
Without counseling, they choice. Then, my lord, the university addressed letter to the government. Government, my lord, sought clarification, directed the university to seek clarification from the NMC. My lord, NMC, my lord, this is the letter written by the NMC. My lord, that is at page 17. Pursuant to the letters addressed by the university, my lord, NMC answered operative portion, page 18, below para 7.
Every day, madam, flag, where is it? Hey, we could have heard it tomorrow also. There was no urgency like.
There is not, yes.
Yes.
University, my lord, the address the letter seeking clarification. My lord, NMC, my lord, my lord, the proceedings dated 24/7. That's me pleased to see, my lord. 7/11/2023 stating, my lord, para 18, my lord, para 7. In the above context, it is directed admissions made by 12 private medical college institutions in respect of any mode is illegal. Said admissions shall be cancelled and students shall be discharged immediately. Then now the university proposing to conduct counseling for the 86 seats. My friend says, my lord, they were admitted, 20% of course is completed within 1 month. Admissions are made 30th September. We are in November.
My lord, tomorrow the counseling starts, my lord. That is the only urgency, man.
Ah.
And according to their own schedule, my lord, the classes commenced. It is not according to college's state schedule.
No, he is only saying about 20%.
Yes.
Within 1 month, 20% of the course is over. That's what he's saying.
Yeah, my lord, 20% of the course is over. The reason is, my lord, we had already compressed it because of the schedule. The number of days that were coming was less, my lord. Now further delay admission at this point when 20% of the course is
No. Let him complete. We will. Yes.
Let my submission lordship says, my lord.
Also, they have got into these colleges illegally. Therefore, National Medical Council has
Cancel their admissions.
All right.
My lord, therefore, my lord, the university, my lord, issued a notification proposing to conduct counseling. They are at liberty to participate. My lord, admissions will be made on the basis of merit. But they have no right, my lord, because
No, but they have not been allotted seats in any of the rounds of.
No, any of the rounds.
Not a. So how they have got into it?
Well, lots of
colleges.
Colleges on their own, my lord. Their own 30th September.
1 minute.
Colleges on their own. And 30th September is being the last date. Subsequently, it was extended. They admitted and sent, my lord, page 22, my lord. Page 22. Lots of have a look at page 22. Lord, the letter is addressed by the Lord Apollo Institute of Medical Sciences and Research to the Vice Chancellor stating, with reference to the letter number cited above, we would like to get your notice. After stray round of vacancies on 39/2023, there are 7 vacancies in the management quota, 4 vacancies in B category, 3 vacancies in C category, and there was no scope for further online counseling process to fill up the vacancies, which arose since last date for admission 39/2023. We had to fill up the vacancies with following qualified eligible candidates who have approached us for admission on that date, which is records at so and so, so and so. Then last page 23. And therefore, last page 23, last page. Thereupon, we submitted that said list to the esteemed university. The esteemed university may also appreciate the fact that non-filling up the 7 seats would be a national waste, as held by the Honorable Supreme Court on various occasions. As there was no compromise on merit, we kindly request you consider the above as has been considered earlier, ratify their admission choice. The pursuant to this, Millard,
Yes.
Page 20, Millard, university refused to approve their admissions.
Page
20, Millard. Pursuant to the letter, Millard. Last paragraph. Your proposal along with enclosed deeds are being reverted back. Any further course of action in this regard will be possible for with approval of educational superior. State governments, it is not appropriate for the university to approve these admissions contrary to NMC guidelines. They are not approved. Then the university will address letter to the government seeking clarification. University, your state government will have the directed the university to seek clarification from the NMC. The university addressed letter to the NMC seeking clarification about in this regard. But they addressed a letter below that just now I let below 7/11/23 at page
18.
Page 17, 18. Well, they are challenging this note, this letter, my lord.
With your permission,
Yes, Mr.
my lords, I'm sorry for appearing on
One point, my lord, page 24 for a second, ma'am.
No. How have you got into the colleges? Like in a manner known to law?
Yes, ma'am. Page 24 for a second, my lord, then I'll explain what your lordship's question also. Sorry, your lordship's page 24 for a second. Page 24, my lord. All the NEET UG 23 eligible candidates are hereby informed that to prevent wastage of precious medical seats, Ministry of Health, Family Welfare approach the Honorable Supreme Court of India so and so in extension of admission. My lord, my respectful submission to your lordships is, my lord, there can be no admission without going online, man. I made admissions based on my merit online, my lord. Then stray vacancies on that, there were vacancies, so I was admitted by the college. There is nothing like without online, my lord, there is no admission procedure at all. So
under which regulation or this thing rule the college is entitled to admit students on its own?
Not in the stray vacancy, the procedure is, my lord.
Where which rule?
2 or 3
Also, you have understood the query. We want to know that you have been admitted in accordance with the regulation by the colleges.
Now, my lord, the next point is.
No, but admission, Mr. As we understand, admission to any MBBS course is held by way of this thing.
Yes. Now I can. They want to have another round of counseling. I am eligible to attend that counseling also, man.
Yes. So you, but he said you can participate in that round. He says so.
Yes, your lordship may permit me to participate, my lord. Have the matter tomorrow, my lord. Tomorrow counseling starts. Your lordship may permit me to participate in the counseling and hear this matter threadbare tomorrow, my lord. Your lordships have, my lord, question how I was considered for admission. I'll place before your lordships, my lord. Meanwhile, your lordship may permit me to appear in the counseling.
There is no meanwhile, Mister. It's on your request. We have gone offline and taking it this thing. On your request, urgency of the matter, it's your duty to argue. Don't speak like an adjournment.
Yes. No, not adjournment, my lord. My respectful submission is, my lord.
So you tell us under which regulation permits the college to admit the students on its own and seek ratification of the university thereafter. Which provision?
My lord, the rules, regulations and provisions have not been filed in view of the urgency. I have told by the advocate on record.
Then nothing. What can be done?
I asked the same question, my lord. But
then how can you get an interim order? You participate if you can.
That's the only reason, my lord.
You participate, Mister. You can if you can. We will not intervene.
Yes.
If you want time, we will grant you time.
Your lordship may say, my lord, that permitted to move the.
No.
My lord, your lordship may clarify.
No. He is saying you rely on the statement of Mr. Rao. He has said that you are entitled to apply and participate. You apply.
I've already applied, my lord. See, that may be recorded, my lord, because I have come to court. College also is against.
No. Why come to the court without showing documents and what basis?
My lord,
as of now, Mr. Please appreciate, as of now, we do not have any ground to entertain the petition. Entry is obviously devotes the regulations and it can't be protected by way of an interim. This is how, until we are satisfied that the petition is maintainable, how an interim order can be granted merely because you have not filed rules and regulations. Therefore, we will grant. No.
Yes, I agree, my lord. I totally agree. My lord, My one submission is, my lord, before your lordship.
Oh, where is Mr. M. Gopal? His name is not there. M. Gopal, has he been admitted?
That is father, my lord. Father and son. Father and son, my lord. Father and son.
Huh? There is only one candidate, right? Oh, we thought that Mr. M. Gopal is also seeking admission. Oh.
No, M. Gopal is the father, my lord. And your lordship may think the son of M. Gopal. M. Gopal is added as a formal party, my lord.
Ramesh Kumar Yadav. He is serial number 7.
Ranks accrued by the petitioner, 4,56,300.
All India, my lord. It is
4,56,034.
Yes, all India, my lord.
34. Please show, Mr. If you want an interim order, show that you have been admitted to the course in accordance with regulation.
No, my lord, these regulations are not filed. My only submission is.
So you file it whenever you want.
No, one submit. The college also is against me, my lord. It says I am bound by NMC regulations. But
we don't know, Mr. Who is against you, who is in your favor. That we don't know. We are asking you legal questions which are from.
Right now, my
you
lord,
please answer that, or you seek time. There's no whatever choice is yours.
Your lordship, my lord, I would like to submit that the petitioner wishes to, my lord, join the counselling that may be ordered now. That has been
It is not. It can't be this. This is a dangerous precedent. Without making out a case, you are say that he should be permitted. Why? What basis? If you are entitled, you participate.
I already have a.
This is no. Will not do it.
Then, my lord, I'll file a letter tomorrow. Your lordship have it, my lord.
Huh?
My lord, I'll seek instructions and proper.
Learned counsel for the when a query was put to learned counsel.
I'm grateful, man.
Day after tomorrow is Saturday, right? You have heard, no? So let it be. Let it come like this.
May I please your lordship? I am appearing for the petitioner, my lord, representing Mateen Suresh. This is the writ petition filed, my lord.
Public interest.
Yes. That last occasion, the GP for Social Welfare represented that, my lord, on 16/3/2022, that the proposal forwarded by the respondent number 3 of board in respect of the regulation draft regularization is pending with the state and some breathing time may be granted, my lord. It was granted by this honorable court.
It was not breathing time, sleeping time. So they have slept thereafter. Correct.
My lord, my lord.
Yes. So what? Yes, Mr. What do you say?
In this, the file is under circulation, lordship. I request another.
What is circulation? This is 2012. 11 years and still circulation.
Circulation with the legal department, lordship, subject to verification.
We'll post it in January or December last week.
I'm grateful.
Huh? No, what is 16th March 2022, 1 year and 7 months ago, you were granted time. Say,
Lordship, finally, my request for in January 2nd week.
Why? We are saying December, that's why you have to oppose whatever comes from the court. So therefore you cannot agree.
File is under circulation, Lordship, with the legal department.
So circulation means have you framed the draft regulations?
Just now I spoke to the concerned principal secretary.
Write down in this petition which has been let the new person who will appear will face the music, right? Huh? Feeling a sense of relief. I mean, at least note down, mister, you have to write. This is an order of the court. There is nothing like because of impending elections, we are not, otherwise we would have proceeded against you. You note down at least order of the court. You are smiling at us.
I noted.
As if that not bothered. The new man who will appear in my place will face the music. I will not be there.
I noted.
This is the attitude. And what happens if you alone appear then? What will you do? Yes.
Much obliged, man.
Procedure.
Yes. This is also PIL. All they have listed PIL.
And about 167 acres of government land on the outskirts of.
We are really amazed at this thing. Awareness here about the government land. Really, all petitions government land.
Nowadays, nowadays realtors, politicians.
So I mean, in the fond hope that supposing if one day an order is passed in your favor, you can stake a claim for in future for regularization of that land, right? So this in lighter vein. So all the petitions are about government lands. We wonder that how, I mean, citizens are really hats off. Awareness level is so much, government doesn't bother, it's about its properties, people do. Everybody this.
Citizens are bothered about it.
Yes.
What happened about 167?
Good criminal cases registered, declaring government memo. CBCID complete the investigation. In one case also like this, it was, but these people who have served this thing country, They should, we think that prima facie, subject to what you argue, are entitled to live in peace, right? They should not be dragged to courts. Having served the country, these people, if supposing.
They have served the country, they should not be touched.
Huh?
They should not be touched.
No, not touched means they should not be unnecessarily dragged to litigation, right? Unless you make out an exceptionally good case.
It's not my prayer, Mila, it's a vigilance report. Page 23, Rashma, kindly see the impugned memo.
Wait, what is the memo? What has happened? You
What happened, Mila, about 167 acres of valuable government property just outskirts of Hyderabad is allotted to about 56 people alleged to be freedom fighters. By the
so they are, all of them are parties. No.
None of them are freedom fighters. They are not aware of this. Their bogus proceedings are created by the embargo by backdate.
You are also an ex-serviceman? No.
I am not ex-serviceman.
Well, who are you?
This is a journalist, Mila. This is a journalist. I have given a brief description of
Journalist? Oh. And so you can't get this land ever, right? Even if it is quashed.
No, the quashing does not have what happened. After that, the representatives were given, news has come in the papers, then a detailed investigation conducted by the Vigilance and Enforcement Department of the state. Kindly, the report of the Vigilance and Enforcement Department, there are two reports were submitted by them in respect of 35 acres, one report, and about the remaining extent another report, which is there on page number 38 minute. First report. 38 dated 13/9/2007.
So only district collector is a party in this petition. District collector, state of Telangana, chief commissioner.
Yes.
So what is the prayer? I mean, what? So government land, 37 acres or whatever acres has been illegally allotted to persons who are not freedom fighters. Acha. Then when it was allotted?
2004, Milad.
So what did you do?
After that, the inquiry was conducted by the Vigilance and Enforcement Department. The report is there on page 38.
No, so what is it? I mean, what has been said in the report? If you can briefly, we will go to all pages, but if you are here, so we have the benefit of your assistance, right?
Yes,
what happened? So
what happened? They recommended that all this land should be cancelled, resumed back to the government, and disciplinary action should be initiated against the government servants who are responsible to create this bogus record, and also the assignment committee members. A criminal sheet should be registered, and it should be entrusted to the CBCID or the sections which are there in the prayer mirror. Another report is also submitted, which is dated on the.
So what your grievance is that no action has been taken on this report?
What happened after that? The appears to the assignment review committee members are some are politicians. They made representation saying that there is no such recommendation. The government issued this impugned GIVO, which is there on page number 23. May I read, Millard? The Chief Commissioner of Land Administration Hyderabad is informed that Sri so-and-so and other public entities have represented to the government that on a complaint made by so-and-so on the irregular assignment of land in survey number 343-1 of Aminpur village of Patanchir Mandal, an inquiry was conducted and the land was resumed in favor of the government. On the cancellation of assignment of land under political surplus category, the purchaser of the said land, I approached the Honorable Court requesting for cancellation of the orders issued for the redemption of the land, and the High Court has issued directions on 8/2/2007 in WP number so-and-so, direct the petitioner to submit explanation to the Joint Collector and request for the necessary action against the concerned review committee members. On this, the Vigilance and Enforcement Department has conducted inquiry and submitted its report. The Honorable Legislature represented that there is no recommendation for initiation of criminal action against the members of Assignment Review Committee, either by the Vigilance and Enforcement Department or High Court. But contrary to the above, the Chief Commissioner of Land Administration Hyderabad has issued proceedings to the Collector of Medan District for initiating criminal action by reference first and cited. It is also brought to the notice of the government that no loss is caused for the government since the land was already resumed in favor of the government and is under position of the government. So therefore request the government to drop the proposed criminal action against the officials and non-officials and take departmental action against the government officials. Government has examined the issue and decided to keep the orders of the Chief Commissioner of Land Administration as was referred to in the reference first and second in abeyance with immediate effect. The Chief Commissioner of Land Administration Hyderabad is therefore requested to take action accordingly and submit reports with demands immediately.
So land has already been resumed.
Land is resumed. But by the time they have also made into plots sold some third persons, there may be litigation. And in fact, the Honorable Court earlier direction, which is there, the directions of the Honorable Court there in page 159. The persons whose allotment was cancelled, they came to this honorable court.
159.
Yes, page 159, minute.
Now, so what is this order?
Whereas the as
Uh,
the
page-
exemption orders, my lords, the aggrieved party have opposed this court. As this court
So what
find fault-
happened?
This court find fault with the manner in which it was allotted and my lords recommended for action against the concerned officers as well as the assignment committee. But only interfered to the extent that since there was no opportunity given to these petitioners, an opportunity was given, my lords. But pursuant to that, my lords, no explanation was submitted by these petitioners.
Petitioners? A petitioner is a journalist. He has papers to question everyone. He can't be asked to submit any explanation.
Page 173, my lords, of this order.
No, no. So what is, like, the land has been resumed, it is the possession of the government. Now what the grievance is that action is not being taken.
In fact, this honorable court directed the action, page 175, Milad.
Yes, Mr.
Parent 70, writ prints are disposed directing the petitioner to submit explanation treating the impugned order dated 27/1/2007. I show cause notice within 10 days from today. And submission of such explanation, the first response is directed to consider the same and pass appropriate orders against with the law within 10 days thereafter. Also take appropriate action against the second respondent, Mandal Revenue Officer Patacheru, and the concerned review committee members who approved the proposal of assignment on 13/4/2005 for the illegally committed by till the explanation submitted to the petitioner and disposed of status quo obtained as on today as regards the nature of position of the assigned lands in question has been maintained. This is the direction of this honorable court. After that, inquiry was conducted. Then last may kindly see the recommendation of the Vigilance Department. Page 83. The report starts on page 38, Milad. Recommendations are on page 83. Findings will have got, Milad. First point, realtors in collusion with the middlemen obtained signatures of number of freedom fighters, their spouses of Karnal, Warangal and Nalgonda districts on white papers in the year 2004, stating that they would get their pension enhanced and also get them house sites allotted. On this pretext, they collected copies of pension documents from them. These papers were converted into applications for allotment of agricultural land in survey number so and so and submitted to the collector Sangareddy. Then you ask me kindly see pair of 4, Milad. Out of 19 applicants, 17 have showed their care of address as P. Janardhan Reddy, Patrika Nagar so and so. It appears that P. Janardhan Reddy has entered the applications on the benami names of freedom fighters. Then you ask me kindly 9, Milad. The assignment review committee with so and so leader reviewed the above proposals on 24/1/2005 and approved assignment 5 acres for agricultural land. Each of the said two applicants about the applicant is survey number so and so. The joint collector through so and so clarified to the MRO Patacheru that Amarizable is not under the purview of HUDA. The letter, the signature of RDO sent on behalf of the joint collector indicating that the office copy was approved by the joint collector was found to be non-available in the office records and the number was found to be non-existent. Then 14 we aspect kindly similar. The Mandal Revenue Officer himself written the note file on 21/2005 that the land in survey number 348 was not fit for cultivation and comes within the purview of HUDA. Contrary to his own note, submitted proposal to the assignment review committee for assignment of land to an extent of 5 acres east to the 5 applicants in survey number so and so. Then we ask my kindly similar, para 16 and 85. Again, the review committee consists of so and so, so and so, so and so. I have approved the proposal of Mandal Revenue
So
Officer.
the grievance is confined to that no action has been taken against officer of the government,
No,
right?
what is the recommendation there? I have come to your lordship. The recommendations there on page 89.
No, we want to, like, we will go to every page, Mr. What is grievance?
Grievance is?
Now land is resumed in favor, it is in possession.
Yes, Milad.
Now what do you want in this petition?
Milad, collector has directed registration of criminal cases. But that is on page number.
So the confined, that's what we are asking you to.
Yes,
the
confined only.
grievance is confined to inaction on the part of against them for they have not taken any action against the delinquents.
What is the recommendation made by the Vigilance Commission that should be given effect to?
Where is the recommendation, Vigilance Commission? Which page?
89 minutes. 89.
Page 89 recommendations, Milad. One recommendation, first one.
Oh, this is what committee you said? Vigilance Committee.
Vigilance and Enforcement Department of the government.
Vigilance and enforcement.
Yes.
So, Mr. Have you, how this is?
This is headed by an IPS officer. IPS officer. Director General of Vigilance and Enforcement. This report is given by Director General of Vigilance and Enforcement and EO Principal Secretary to Government GAD.
That's in fact the fourth respondent minutes has pursuance of this vigilance report has recommended for initiation of the action. Subsequently, minutes government at page 23 minutes thought it fit to drop the action.
Why? Thought it fit means it can't be like.
In view of the representation made by the minutes.
And there are vigilant persons like petitioner in this society. You cannot do anything like you feel. Let drop. What?
This is also not drop, only review. Kept abeyance.
Why? What reason? This all, Mr.
In the counter, they say minutes that the land is already taken back and there is no loss to the government. That is the reasons.
No, but no, supposing if a person commits a theft, right, and the amount of one minute theft is recovered, will the thief be let off? But no loss caused, and this amount has been seized and recovered. How can you do this, Miss?
That is the. And the disciplinary proceedings were also dropped.
No, and you see, you have decided to stay the proceeding, stay the order, or something like that. No word used is stay.
Abeyance.
Abeyance. How? You are not setting it aside or nothing like. Abeyance means what? Why? How?
That is put to challenge minutes in this public interest. Only explanation given is minutes.
No, Mr. Mr. If you have kept it in abeyance, that means temporarily suspended, right? So you have to, at some point of time, you have to take a decision on this. You can't get away by saying that we will not do it or this thing.
So please, minutes, I seek instructions. I'll get instructions minutes in this regard minutes from the.
This has to be done.
That's correct. And in fact, this court also directed.
90. Yes. In this a personal thing what you want.
Yes.
Like your pound of flesh, I only want this much, not the whole body.
Yes.
We have to examine it.
Page 90.
So what is the chief admin? 1 minute.
Yes.
Initiating against, see, as consider initiating against IS. What consider?
Which one?
Against Prasad Reddy, then joint registrar, now retired joint registrar.
A prayer is not-
Recommendation, page 89.
89. Yes, Milord. Page,
You have to quote from page 89.
90, page Lord's Back, Milord. Get a criminal case registered and entrust to CBCID against.
No, you are only reading a part of it which is convenient, right? There are other directions also.
No, I am only asking for this direction to be implemented.
No. That's what we are saying, that in a public interest litigation, you cannot have your pound of flesh. I only want this. So therefore, I will not implement them.
Department action was dropped. I am not questioning the department action because it's a service matter. So that
Our question is, it has to be implemented as a whole when we are satisfied prima facie that there is no justification. You cannot say that, no, I will not implement them because I want FIR to be registered against them. This is a very convenient difference, right? But as a court, we have to, how can we, this thing, because can we say that because petitioner wants a registration of FIR only, therefore it is not necessary to be heard and FIR should be registered? Can we pass an order like this?
No.
Correct.
For the,
This order, Mr. We'll have to implement. We agree with submission made, but it has to be passed after hearing them. See, Mr.
Subject to what your Lord will say, may I say this, Milord?
No.
Yes.
We will have to implement them. That's what we.
To get a criminal case registered, Milord? To get a criminal case registered?
Not criminal case registered, Mr. This much of law we also understand. That for FIR, if somebody is caught committing theft in your house, will you give him a notice that I am going to lodge an FIR? What you have to say? This basic we must understand. We cannot say that although this recommendation has been made, petitioner is only interested in lodging FIR. Therefore, it is not necessary to impede anybody and principles of natural justice do not apply and therefore it should be registered. We can't issue. There are a series of directions. Please see recommendation page 89, 90. And this order will not, we can't pass an order. This flaw, basic, we will not this thing commit.
Before that, Milord, may I request Lordship see page 24, Milord? Page 24. Page 24, Milord?
No.
I got it, Milord. After going through this.
We are satisfied. Please, 1 minute. Please understand. We are convinced that these all recommendations have to be implemented. But we have seen the cost title. These people are not party to the petition. We will go to Supreme Court and say that High Court has not heard us and they are ordering everything. We cannot implement direction of implementations selectively. That only FIR should be registered, nothing should be done.
May I submit, Milord, after that, Judge may form the opinion. Page 24, Judge may for a minute. Page 24, Milord.
No, but why is the hesitation in
No hesitation. I will make the parties. Before that,
please.
I just bring to your Lordship notice that after that also your Lordship want me to make the parties. I will make the parties. There is no issue in that, Milord. Page 24, you have 25, Lord may see for a minute, Milord. A copy of the reference cited to the with a copy of the vigilance and enforcement report dated is furnished to the herewith to Collector Medak. He is requested to take immediate necessary action. I suggested on the item number 4, 2, 3, 2 to 7 of the findings of the vigilance and enforcement report and report complaints directed to the government and replied to the service positively. Then last can see next one, 25. Copies of the reference site are enclosed. The Collector Medak district is request to book a criminal case against so and so. And other suggested by the VND department and government and keep informing this office about the stage of the criminal case. These two are kept in abeyance by the government. These two memos these two directions issued by the regulator are kept in abeyance. And what happened, Milord, against the officers' different action, they have initiated draft page number 26. I am not asking that. Page number 26 is that as far as departmental action is concerned, they have initiated and government after considering their expectation it is drafted on page 26. So I am not asking that aspect of the matter, Milord. That's why it has been drafted.
No. See, you are not here in an individual capacity. Your capacity is once we have taken note of public interest litigation, you cannot say that I only want this relief. I want to withdraw the petition now because somebody has approached me. That you can't do, you know it very well.
I'll make the point, my lord.
Please complete.
I will repeat.
Yes, so and so. What have you written? We were allowing the petition, Mr. It struck to us that they are not parties. Hmm. 53.
Please, my lord. This bill notice is filed, my lord, challenging the allotment of park amenities area, my lord, 10.6 acres, to 33 persons, my lord, as the outside. The government made a layout, my lord, and allotted plots to 299 persons. Left this 10.6 for a park as well as amenities area. Now this is open area also they want to allot to the 33%. That we have challenged in before your lordship, my lord. The lordship also now stated that not to make further alienations. So far, the government has not filed any counter, my lord, since 2012.
My lord, there seems to be a counter which is filed, my lord, which says a draft counter in the year 2013.
But not given a copy to us till since the last 10 years.
I will serve a copy. But as the matter stands, my
It's
lord.
all public interest litigation at your cost, like at their cost, but at you in respect of your property.
Yes. Here
So give him, allot him some house site, he will also get. So
there are two.
Well, we are amazed really that people are so aware about the public properties and this thing. 33 persons outsides.
My lord, the 33 persons.
So what is your this thing? Counter?
The
What
submission is, my lord, the 33.
Are you opposing the prayer? So then you need to supply him copy.
No, my lord, in all, my lord, 590 beneficiaries were identified.
No, whatever. You need
There are
to.
two open plots kept, my lord.
Two open. There are two petitioners.
No, they are.
One petitioner.
The contention of the petitioner is that entire land has been taken.
No lighter vein, madam,
No,
nothing
I
to do with this thing. I mean, at 3, we can't remain all the day very serious. So you have one plot, give it to him.
There are two open plots, my lord.
So give him a choice which one he wants. And so we will dispose it of that grievance of the petitioner stands redressed. His plot has been allotted to him.
No, I'm not.
No, lighter vein we said, Mr. Nothing to do with subject. So, madam, you need to, in case you are contesting, what is it? Draft counter means what?
My lord, I do not, that
Then
was an instruction given, my lord.
He says that you need to supply him.
I will
copy.
supply.
Supply.
Yes.
Learned counsel for the respondent, whatever, right?
Much obliged.
That's all. Government land. No, okay. Oh, for a change. Good. What is it?
There is a bond in Morali area that the read the bond without there be any NC.
Ah.
8 years has been occurred.
My instructions are not, there is no pond as of now, not has been closed long back.
Huh?
Today's instructions, there is no pond existing as on today.
Encroached like multi-storied
It has
buildings.
been developed as a layout and the houses have been built.
See, that's what. Exactly, that's what we wanted. Where would the ponds? On pond itself, you have constructed allotted plots.
It's not a pond, it's a well. Well on a patta land.
Patta land.
Not Patalat, there's a counter, is a Sarkari law. Well, the someone, the eight respondent filed appeal, which has been allowed in their favor. Against which they prefer the second appeal because it's on foot, which has been paid.
In that appeal, subject to you, what? See, Mr. Now, what is this thing that this thing, as they say, what are your this thing? It pond does not exist.
Not as per their counter, they are trying to fence, they have to obtain permission from the district collector. As the year 2012.
Today's instruction notes, the revenue officer inspected the survey numbers plot and had informed me that there is no well, whatever the trench plot is not existing as on today.
You file additional affidavit.
Yes.
Learn it so and so GP for revenue.
May it please your lordships, we are filing the Wakalat in this case as previous council has moved to Amravati. I seek
No,
some time,
this is a PIL, madam.
Yes, your lordship.
This is not a adversarial litigation, right?
Lordship,
PIL, you will not get anything out of this.
I seek some time, your lordship, so that we can obtain the files and argue the matter in the next date.
This matter, I'm for the respondent 2 and 3. They filed the public interest litigation against the state, questioning against the state, questioning the ICT policy, that's the Information Communication Technology Policy of 2005. The petitioners are were the formal employees of R2 and R3, not respondent 2 and 3. So respondent 2 and 3 have got no role to play, my lord, in the public interest litigation, which is.
So they are in fact aggrieved persons.
Yes, my lord. That is what is their contention, but they have even made a company, an information technology company, my lord, Wipro, as a respondent.
Declaring the inaction of the monitoring ICT policy.
Relief is not claimed against R2 and R3.
Fine. Failure in protecting. What is the relief, madam? Read page 4.
I apologize.
No. This is a public interest litigation, madam.
I will obtain the files at your lordship.
So don't opt in. There is no need to opt in. We will not adjourn.
Lordship.
You are unable to assist, right? Then we will go through it.
Lordship, I'm here to seek some time so that we can assist the honorable court effectively in the next day.
No, 11 years, madam. We will effectively assist ourselves today itself. You need not bother for tomorrow. Nothing. Don't bother. We will assist ourselves effectively. It's a public interest litigation. And not after 11 years when the case is called for hearing, you should tell the court that we are filing counter. We see once we take cognizance of a public interest litigation, it is for us to deal with it.
Filing the NFC Wakalat, your lordship.
Don't file. This is not an adversarial litigation. If you want any relief for yourself, we will permit you to withdraw with the liberty. They are former employees claiming the relief from themselves, and most vague manner we are unable to comprehend what you have prayed for. Just if you can see. It will not be adjourned, that's for sure. It has been dismissed for want of prosecution also. That shows the manner in which you are prosecuting it. Fine. No element of public interest. Yes. They were former employees of Wipro.
Yes, my lord.
All right. The petitioners mark the presence. The petitioners who are the petitioner appears to be persons aggrieved by so and so non-implementation of what policy you see from the prayer clause, right? And no element of public interest, therefore investigation. Yes. Yes. Huh? Ah, yes. Why don't you allot the land to the petitioner? They are required to file public interest litigation. You don't allot them lands and they file that you are allotting it to somebody else. Lighter, Mr. Nothing to, we will hear you, don't worry. Huh? All public interest litigation about the government land only. All everything. Direction to declare impugned order. Hence.
There is an interim order in this matter, my lord.
Bhavi in existing to for Kabristan. Illegal arbitrary. This is not a PIL, Mr. That your person agreed, right? You don't want the land of your village to be used for the purposes of graveyard, right? But then, how is it a public interest litigation? Huh? What if, 1 minute. See, you are the person aggrieved. How can it be a PIL? You reside in that very village. You are not a generalist, right? Social worker residing in that very village where graveyard is being like they want to use. You are the person aggrieved, but this is not a PIL. No, please. We are not saying that you don't have a merit. What we are only trying to tell you is that this is not a public interest. You are a person aggrieved. It can be, your petition may be maintainable, can be allowed, whatever, but not a no public interest. Huh? So what is, there is a concept of what, it's a petition on behalf of all the villagers. So petition is in a representative capacity. There is a village to the committees, not a party. Apart from that, if two people approach and supposing 100 are affected, huh? You understand what we are trying to tell you. So like if 100 persons are affected, right? Whole village is affected, say 100, and two file petition, it does not become public interest litigation. It is a writ petition in representative capacity. Something like Order 1 Rule 8, right? Section 92, something like that. It's a representative action. So we will say that it should be treated as a writ petition at the instance of an aggrieved person, be listed before single bench. So, madam, what is it? Is it a water body?
It is a spring, water spring, madam.
So then don't, there is an order.
There was an order by this honorable court to maintain status quo.
So you are maintaining for 10 years status quo. So maintain for another remainder lifetime of petitioner.
Your Lordship, there is no counter file, my lord, in this matter.
What should 10 years, madam? What do you expect us to do? Like after 10 years, granting you time to file counter, what?
In my lord, 2013, there was an order till the disposal of the appeal not to allot the said land to anybody.
Then
Counter has not been.
we
filed.
hope that you are maintaining.
Sometime
In the light of interim order dated 30/12/2013 passed by division bench of this. No, government land. 57.
Yeah, this one is an appeal filed by
This
the.
appeal is preferred by the state government.
Oh, not PIL.
Not. Against review petition, my lord, this intra-court appeal arises. And the petition has been allowed, my lord, with the direction to pay ex gratia to the respondents herein. And a review has been filed against that order, my lord, on the ground that already ex gratia has been paid to the encroachers who were there in the land at the time of survey conducted, and they were in the possession. And thereafter, the petitioners, the respondents here in my lord, are being granted other land, my lord, in lieu of the assigned land.
Yes, madam.
This appeal, my lord, is preferred against the review order, my lord, wherein the writ petition has been allowed directing to grant ex gratia, my lord, to the respondents in the appeal. And against that, an review petition has been filed, my lord, seeking review of the writ order. That review has been dismissed, my lord, confirming the same order, my lord. And the petitioners, the respondents herein are the assignees. It is not disputed, my lord, and they have been assigned, but they were never in possession. And at the time of resuming the lands, some other persons, my lord, who are impleaded in the writ appeal were in possession and.
Yes.
They were in possession, my lord, and they have been granted ex gratia. And the respondents herein has been allotted other land, my lord, in other survey numbers.
How do you meet para 5, madam? 6 of the order rejecting the review petition? You have not disputed that they were assigned the lands.
Yes.
Then you did not file any document before the learned single judge to say that that the proceeding for assumption of land were initiated against the petitioners.
Correct.
Then
But the other, the petitioners, in lieu of this land, my lord, has been allotted other lands, other forest lands, my lord, that has also not been disputed by the respondents herein. They are in possession of those lands.
no, please read what letter.
Yes.
Why your review petition has been dismissed? This is not an original proceeding writ petition where you are arguing. Like this is review it has been serious observations have been made with regard to conduct of your officers.
Yes, I'll read it. From paragraph 2, my lord, I'll read. Writ petition.
No, you must have read it, madam.
Yes.
You believe that you have read it. If you want to, whatever, do it, read. Nothing right. Para 5, 6, and 7.
There is no dispute, my lord.
Not in position.
The only ground, my lord,
Discloses the fraud higher level was played. Only the rate petitions. Yes.
the only ground raised is that, there is no dispute regarding the assignment to the respondents herein. And neither there is any dispute, my lord, regarding that there was no resumption, my lord. There is no resumption at all. But the only ground which has not been considered in the review petition is, my lord, that the petitioner, the respondents herein were not in the position while a survey has been conducted. There were some other persons were in position, and hence the ex gratia has been paid to those persons, my lord. And they are impleaded now in this writ appeal as it has been directed by this honorable court to implead them. And regarding the in view of this assignment made to the respondents herein, another land has been given to the respondents, my lord, in lieu of this land, because at that time of survey, the respondents were not in possession. This is the only ground, my lord.
No, how do you meet the issue of fraud? There has been a fraud being played, that's been reported, finding to that effect. What is your ground on that appeal?
Yes, my lord, I've seen that. But regarding the fraud, my lord, it's no fraud is, I can only plead that no fraud has been.
See, you have filed an appeal.
Yes.
There's a clear finding on fraud. How do you meet that? What is your ground on that?
Can orally say, my lord, because at that.
But it's rightly granted. You please to review my content. We are really able to speak to third parties. They can't be defined to clearly this ability argument to document.
Yes.
The only ground I can take in this, my lord, is that regarding the fraud, my lord, no ground has been taken, my lord. Only I can plead to your lordships is that the assignment is not disputed. But when the inquiry has been conducted on the ground level, the respondents herein were not in possession, and the encroachers who were there in possession only has been granted, my lord. For them, they have been made a party. It's not that, my lord, we have done any fraud. At that point of time, who were there in possession only have been granted ex gratia, my lord.
Without making enquiry, on what basis you paid ex gratia? You paid to anybody there on the plot? It was
No, my
proper
lord.
enquiry.
Yes, my lord. Only local inquiry, when it has been conducted on the field inquiry, my lord, it has been conducted. And the persons who are on the land, my lord, at the point of time of inquiry, they have been paid ex gratia.
That's it?
Yes.
Yes, madam. This appeal, this intra-court appeal under say.
Obliged.
Say, which is 50, madam? Huh? 57.
58, all three matters are same matter.
Yes.
Two are against with regard to reviews and one is with regard to against original.
For the
Obliged.
The time for the response rapporteur. Appeal is filed against the petition number 1 or in the review. Or in the review. The three grounds of objection which I am raising against the petition, my lord. One is a discriminatory in nature. My lord, notice was given only to us because in the pylon neighborhood, my lord, there are other temples, mosques and other, there is a colony which has been existing in that, my lord. Instead of giving notice to anyone, only we were one singled out in giving a notice to.
Hey, what has been done? Constitution of India to appropriate direction, mandamus impugned notice. Arbitrary. What is the notice? 8/6/2009.
Page number 22, my lord. The impugned notice is on page number 22. Shahid. But the notice directs us to find a suitable, identifying a suitable land for relocating the appellant institution, that is Dattapeetham temple complex, outside the security zone. Well, till today, security zone has not been defined or demarcated. Well, when the security zone has not been defined or demarcated, they can't state that I am in the security zone, so I have to be moved backward by 1 or 1.3 kilometers. I've been making representations to the authority, my lord, the second and third respondent, to show me a map or show me exactly where the security zone lies and where I have.
Only on one is this, other one is there was no security zone which was demarcated or defined. And the third is, my lord, there was a high power company which was established in the year 1990s. High powered company which was established in the year 1997. My lord, which is on page number 33.
No, whether this land has been allotted to you.
No, my lord, it was not allotted to us.
Then, does it belong to you? How come you are in possession of that land?
My lord, it was, my lord, at that point of time, my lord, in 1974, no one was inhabiting. There was a temple which we have built and a meditation complex which we have built over there. My lord. Later, my lord, there was a because of population has increased over there nearby the dam. There was a high level committee which was
No, but this semester, please appreciate the temple is inside. I mean, like now this thing, the dam, whatever.
No, my lord, the only thing is they say that it's inside the security zone. But the security zone has not been defined or demarcated is our question, my lord. We made many representations to the authority to.
No, what happened to this thing? How much is the area you have encroached?
It will be 1.55 acres, around 2 acres.
Then it's like
My lord,
it was a government land, right? It's a government land.
yeah, my lord,
You don't have any title.
don't have any title.
What have you done? Constructed temple?
So only temple and a meditation center, my lord, nothing more.
Nothing more means like what
you have been
you want to.
relocated. You have been given an opportunity for relocation. There was a suggestion for relocation.
My lord, yes,
What
my lord.
have you done for that? Have you
My
made
lord,
any efforts?
Yes, my lord, there was a suggestion for relocation to relocate beyond the security zone. My lord, we made a number of representations to tell us what exactly falls within the security
See,
zone of
security
the Nagarjuna
zone
Tower.
and all that will be confidential. It need not be disclosed.
My lord, but at the same
See,
time,
the point for concern is that are you having any authority to construct there or not? You have been continuing all these years.
we have asked the
Any
government
right
to
has been
regulate.
accrued for you.
My lord, we
Please
have
see,
asked.
it is a dam. It is a dam where when full water level comes up, it may be. And many people come to the ashram. Who takes care of the security aspects? There must be some reason behind it, right?
Yes, but my lord, abetting the dam, my lord, there are other constructions also, my lord. There is a abetting the ashram. There are other constructions also, my lord. There is another temple, there is a mosque, and there is a colony which has been established. Later, my lord, after the committee has high power committee has given suggestions, they have regularized all these.
Yes, is it correct that there are other structures also in the vicinity?
Yes, man, true.
And you have regularized?
Before that, my lord, what happened, my lord? While constructing dam, my lord, for the officers and their families concerned, my lord, we have given permission to run a bank and school and likewise, my lord, government institutions. Later on, my lord, permission was given to run one temple also, my lord, I agree. But my lord, in the year 2006, I think.
Permission to construct has been granted?
No, not this temple. Some other temple, not exactly at this location, my lord, but some far away from this location. This location, my lord, exactly locating towards the upstream of the dam, my lord, very nearer to the dam. In the year 2016, my lord, some terrorists conducted recce at this location, my lord, to destroy the dam. My lord, that is there, my lord, at page number 74. That intelligence report also filed here with my lord. So after seeing all these things, my lord, we have offered them.
Terrorists were staying in the temple.
They're having some rooms at cellar, my lord. In this temple, my lord, they constructed some rooms in the cellar. So after conducting all the inspection, my lord, we came to a conclusion that, my lord, I mean, not we, my lord, irrigation department, police department suggested us, my lord, to evict all these structures from this location because this is the only location, my lord, which is unauthorized.
No, correct. No, but what about his contention that security zone has been notified?
Security zone is deemed, my lord, because my
how
lord,
far is
500 meters.
No, we
150
want
to
to
500 meters.
Yeah,
My lord.
See, Mister, we want to this thing. How far is this temple situate from the dam?
Less than 150 meters, my lord. Less than 150 meters from the dam.
150 meters.
Yes. That is what our case, my lord.
And how they have constructed the temple?
Illegally, my lord. Illegally.
When?
1980, my lord.
And what were you doing?
My lord, because at that point of time we could.
2009, I mean, after you just remembered after 2019.
Because of this intelligence report, my lord. Because of this intelligence report, police asked us to, my lord, take action against these illegal encroachments, my lord. Then we have issued him a notice. My lord, we offered him to relocate some other place.
So you showed, Mister.
Already shown, my lord. Kindly come to, my
No,
lord,
no,
page number
no.
84.
You showed them a place where they can relocate.
My lord, kindly come to page number 84 once, my lord. 84.
84.
Yes.
We appreciate the security concern, right? Nobody can be like inside on a dam.
Yes, yes, yes.
So like, but this thing, what we are saying is give them some alternative this thing so that we can ensure that they shift.
After impugn notice, my lord, we have given them two letters. We have sent them 2 letters, my lord, asking them to, my lord, participate in joint inspection and see the alternative location. My lord, page number 82 is the covering letter, my lord, and 82 is the letter, my lord. It's an internal correspondence, my lord. Later coming to
relocated site, yes.
Yes, 84, my lord. 84 left side is, my lord, existing site.
Hey, Mister, why should you not this thing? Huh? You don't have a title in respect of the land on which you are occupying, right? It's a government land. 150 meters from the dam. How can you this thing be there? Obviously. No, we are not in a this thing, Mister. So like you are being given option to relocate. Why don't you explore this possibility?
Only grievance, my lord, was.
Instead of like asking them to demolish the temple, it's you should take it away. This thing respectfully. And so many cases, like they are giving, they have given you a notice for relocation. How can you continue?
My lord, they have given me alone a notice, my lord. I was singled out.
They're not singled out. This is not the ground, Mister. Where have you this thing? He's saying no other this thing, no other structure.
There is a mosque, my lord.
My lord, nearby this location, my lord, the government institutions are there, my lord. Government institutions are there, my lord. I agree.
No, no.
Even in counter affidavit, my lord, in my
mosque, is it there?
Yes. In counter affidavit, my lord, we stated saying, my lord, some structures are there, and even we are taking action against them also.
See, Mister, two things like this. An amicable solution to this problem has to be found out. Definitely, the security of the dam is like this thing. This is, I mean, we cannot compromise. That's correct. But this thing is his allegation that he has been singled out and others are being allowed to continue.
According to the counter, my lord, he is the only unauthorized construction, my lord.
Well, they have given permission to them, my lord. Even HIGHCOURT company has asked to regularize my permission for them.
Where is that?
My lord, page number.
No, other institution. You file an affidavit. Like, Mister, please find out. We would like to this thing, Mister.
I'll file an affidavit to the extent that
not affidavit. I mean this thing. See, if any other structure is there, everybody you have to treat everybody alike, Mister. They cannot be a threat to the safety of the dam, and other person cannot be private individual cannot be allowed to continue on the ground that whatever we have regularized.
Yes.
This can't be done.
Yes, ma'am.
Right?
Yes.
He also cannot be allowed to continue. We agree with you. But you have to deal with persons uniform on a uniform basis. Take this thing, constructive approach to the whole issue. Not every litigation need not be adversarial in nature. You find certain where they can be relocated. Give them the nearest place where they can be relocated.
My lord, page number 86, my lord, we have shown them location also, my lord. Page number.
Yes.
Kindly come to my lord, page number 86.
Yes, Mister. You also seek instruction. What can you do?
86 is notice. 87, my lord. Location alternative right side, my lord. Left side is existing site. Right side is, my lord, location we have already shown him. 87, page number 87 is.
Where is he presently?
Left side, my lord. Left. Right side, kindly see once, my lord.
How far is the distance?
Only about less than 1.5 kilometer from the dam, my lord.
How much is the area of this temple?
Almost equivalent, my lord, we are giving him. According to this map, almost equivalent we are giving.
But my only grievance was that I was being singled out.
No, where is the in this map?
45, it's not a map which is given by us. Map, if you can just page number
Any
45.
singled out means what, mister?
Look, there are
Singled out means you should be allowed to encroach on a government land. No, we will direct then in case you are able to this thing, we will direct them to remove all encroachments.
Yes.
But this is not, you are just that others are, I am.
Well, only on the point of discrimination I was here.
No, where is in this map, which
map
other
is not
structure? Mister, please understand.
Not in the chapter, they specifically has stated, my lord, regarding permission to temple of Sri Virat Potuluri Veerabambam and Sri Sai
Where
Baba
do we
temple
that
under
other religious
construction.
structure? So this is this one.
This is the community. Earlier, there is a
No, this is what he is there.
Yeah, this time.
And
The other structure is not state bank, modern time, but this should also be renewed if that is okay. These are all government.
so, Mister, on the left hand side, that is the portion. It's a community hall, right? And the temple is somewhere other thing, right? See.
Page number 87, my lord.
Page number what?
87.
That sketch you are showing. 87. Yes, correct.
87, my lord.
87 on the left hand side. This thing there is a something about community is written.
Correct.
Then thereafter you see another. As you go up on that very side, State Bank is written.
My lord, encounter of
1 minute. State Bank.
I agree.
And thereafter there is one temple.
Yes, true.
So whose temple? Their temple?
No, not their temple, my lord. Another temple.
Another temple.
My lord, the permission was given to those temple structures in the year 1990. Before 1990, my lord, GO is also they have placed here. Here, my lord,
Also some huts. There are also some huts.
Huts
are there, labor huts are
in my counter affidavit, my lord, at para number 6, my lord, at page number 41, my lord, we admitted that my lord, all the structures will be removed outside the security zone. I think, my lord, because of pendency of this matter, my lord, our officers are not taking any action in this matter. Let there be a direction, my lord, to remove all the structures if they are causing threat to the dam safety. Because it is stated.
You tell us which are the structures which are causing threat. File an affidavit. We will direct. You file an affidavit that you are willing to take. These are the structures situate in close vicinity of the dam, and they are within the security zone or whatever.
May I read para number 6 of counter, my lord? At page number 41. All these structures names also given here under, my lord.
Para 6.
Para 6, page number 41.
Counter.
No, but security zone has been this thing
It is deemed.
Notified.
After reading all the papers, my lord, what I could understand is, my lord, it is deemed. It is deemed, my lord. 500 meters zone is security zone for this dam. My lord, I'm sorry to bother your lordship, but para number, page number 74, my lord, terrorist names were also given, my lord. Terrorist names were also given. 74 page number. Who conducted recce and who wanted to demolish this dam. This report, my lord, starts from page number 70.
That's in your counter.
No, the same papers, my lord. I'm sorry. I'm having the same papers. Appeal only, my lord. Page number 74, conclusion part, my lord.
What? Where? There is no names, nothing. What?
My lord, page number 17, conclusion part, my lord, after about 1, 2, 3, 4, 5, 6, 6 line, my lord.
Attacks on various ministers.
My lord, arrest of terrorist Abdul Riaz Rahman, who has.
No. What? Conclusion well known. You read from the.
Yes, my lord. It is a well known fact in and out the country that a high degree of threat perception exists in national important structures. Factories, projects, defense installations, and important pilgrimage of worship are being targeted by internationally trained terrorists and other related outfits. Taking into account all the recent developments, this attack on IAS Bangalore, a temple at Varanasi, Akshardham temple in Gujarat, attack on Home Minister Sri Hariyan Pandey, Gujarat, Lower Salur Power Unit, and arrest of terrorist Riaz Rahman, who has disclosed to police authorities under interrogation that he has visited and inspected the NS Dam, Nagavan Sagar Dam, subject dam.
No, but this temple has no links with that terrorist, right? It's not that temple guarded them and.
They suspect that, my lord, this temple being an authorized construction, they're having some source to live there.
This is too far-fetched, Mr. I mean, ideally speaking, it should not exist. They don't have a right, but nowhere it says that they stayed in temple and did Reiki and whatever.
Otherwise, my lord,
anybody can go there, right?
Kindly take my paragraph number 6 of counter affidavit into consideration, my lord. That we have.
No, Mr. What we want is that try to find out an amicable solution, right? Especially in the case of a religious this thing, it's a temple or whatever place of worship. So try to find out and first explore. Otherwise, we are here to decide. Can you this thing, Mr. You also think about it. Don't be like you don't have a right to continue.
Yes, my lord.
Why don't you relocate?
I'll ascertain.
You seek instructions from your clients. Find out which we want you to find out which other structures are there. Any other distinct place of worship is there as he's suggesting, apart from this temple. Correct? And this thing. What about any this thing place of where they can be relocated?
Yes.
So when?
As these upcoming elections are coming.
2 weeks.
No. I'm sorry. Upcoming elections are coming, my lord. All of us are busy with elections, man. Held up in election duties. So.
Learned Council board parties jointly pray for accommodation. One. You call one case. Maybe infructuous. They don't tell us. Yes. Something to argue, right? You are appearing. All right. We'll hear you tomorrow.
Next week. Spread up tomorrow. In here.
Next week. 60, 61.
61 and 62.
61 and 62. List next week. All right. Continue.